please, your lordship. This matter for listing tomorrow, that's some urgency.
For
Listing tomorrow.
For?
I list today.
May please, your lordship. May please, your lordship. Your lordship, I beg to mention for listing of 3 matters for admission, lordship, on next week. Lordship, there's urgency in the matter because it pertains to your lordship, the Gauhati advertisement, lordship. There has been some recent development in the.
I beg to mention for listing on open matter.
tomorrow? Can we have it on Friday? It is not inconvenient. Otherwise, if it is urgent, tomorrow.
Tomorrow, sir, I
May I please, your lordship, I do beg to mention for withdrawal, my lord. For withdrawal of the case, my lord, to
Huh?
be listed, for withdrawal, my lord,
Withdrawal
yes, my lord.
Friday?
Friday, my lord.
My pleasure, lordship. My direct to mention for listing on matter for admission. Possible on this week, my lord.
Pertains to
First dance to my lord, election of a president of Panchayat.
huh?
Election
Of the president of
of a Panchayat.
23rd.
May I please, your lordship? Lordship, I beg to mention an item for listing for motion, lordship, for tomorrow.
Friday?
Lordship, yes, lordship.
Friday?
Friday. Yeah, lordship. Oblige, my lord.
Sure, I beg to mention I matter for listing on 12th February. I matter,
I,
12th February,
okay. When do you want?
12th.
No. Why 12?
Your lordship, it's a eviction matter, eviction.
Eviction.
Stay against eviction notice was passed. So last eviction matter was on, eviction drive will be on 13th February.
12th. But this will be taken up only at 2, huh? Can't be taken up before because I'm sitting at 2.
Okay, one.
Yes, what is your case?
An order has been passed, my lord. It is 25/11/2012 by Principal Commissioner CGST, my lord, confirming the demand, my lord. As my lord, by so-called notice dated 2010/2024, and imposed penalty with interest, my lord. And here, my lord, so-called notice was issued on 2010/2021, to which my lord petitioner submitted his reply, stating that my lord services he rendered, my lord, that those were, my lord, exempted by 2 mega notification, my lord, of 2012. My lord. And that has been although considered by my lord, but when my lord order has been passed, my contention has been rejected on the ground that, my lord, due to non-submission of the relevant, my lord, work orders and contracts with the, my lord, company. And at the time of virtual hearing, my lord, I proposed to submit those documents, but my lord, no option was given. And accordingly, my lord, I could not submit those documents. My lord. If I could submit those documents, my lord, and those were considered, my lord, then, my lord,
No, first of all, what is this type of order which is half typed, half not typed? What is this?
Lord, actually, some portion of the order, my lord, those were not legible.
So why it is part-wise typed, part-wise not typed?
But then I may be allowed to submit the complete type opinion.
No, this is not done. We should dismiss it on that ground itself. Secondly, why haven't you filed an appeal?
My lord, because my lord, my prayer is limited, my lord.
No, your player is not limited.
My
You
prayer
say,
is only for, my lord,
no, no,
consider
no.
the
You
magistrate
say
case.
issue should not be issued directing the respondents to reconsider the applicability of the notification dated so and so and the notification dated so and so. Which are the notifications? Let us see.
Those are annexer 8 and 9, my lord.
Let us see that.
Case 214, my lord.
21,
214,
215.
214.
Yes.
Here, my lord. In first paragraph, my lord, it is stated, my lord, hereby exempts the following taxable services from the whole of the service tax leviable thereon under the 66B of the said act. Now, my lord, clause 12, my lord, page 217. Clause,
Yes.
my lord, 12 and 13, I have rendered my services covered by these, my lord, three clauses, my lord, to the government, my lord, and government agents.
So 12, you come under a 12.
My lord. And it is admitted position, my lord.
No, no. What did you do?
My lord, some construction works, my lord, for the government, my lord.
What?
Those I have, my lord.
Construction of what?
Construction of, my lord, community hall, boundary wall of hospital, bridges, my lord, like this, my lord.
So that would not come?
That will come, my lord. Because,
Where?
my lord,
Where?
because, my lord, these are the services
No,
provided.
no,
to-
where? It says 12 or alteration of, you see, services provided to the government or local authority or government authority by way of construction, erection, fitting, repair, and or alteration of historical monuments,
My lord.
archaeological sites or remains of national importance, archaeological excavations or antiquity specified under the ancient area, canal, dams or other irrigation works, pipelines, conduit or plant or water supply, water treatment, so and so. Did you do any B, C, D, E? Then
Lordship, may kindly see 12 payment. 12 payment. Services provided to the government and local authority.
no, this is not for all. It is only for these A to F. Of which A is gone, C is gone, F is gone. Only B and C. B is D and E. Did you do anything of B, D, and E?
But my lord, understanding is that.
No. Your understanding would not help. When it is said or alteration of, meaning everything will come, then it is not necessary to bring B, C, D, F. Isn't it?
Yes, lord.
That's it.
It is under clause 12, my lord.
Then what else?
But 12A, my lord. 12A, my.
Well,
12A, my lord.
capital A.
12A, capital A.
Services provided to government, a local authority of so and so, construction, fitting, repair, so and so, of a civil structure or any other original works meant predominantly for use other than for commerce, industry, or any other business or profession. Structure meant predominantly for use of educational, clinical, or art or cultural establishment. A residential complex predominantly meant for self-use or the use of their employees or their persons specified in explanation 1 to section 44 under a contract which have been entered into prior to so and so, on which appropriate stamp duty where a leviable have been paid prior to such date, provided nothing contained in this entry shall apply to after the 1st of April 2020, inserted by notification dated 2016. So did you complete the work prior to entered into prior to 1st of March 2015?
Yes, ma'am. Yes, my lord, because
Where?
my assessment has been done only for the financial year 2016 to 17. my lord.
16 to 17.
What
Okay.
I have received, my lord, from the government. And it is admitted that I have received the entire amount from the government, my lord. But it is not clear, my lord, from my documents, my lord, for the authority, whether my services has come under 12 days or 13 days. And because I could not submit, my lord, the work order before the authority at that time, and during the final hearing, my lord, partial hearing, I proposed to submit those documents, my lord. But no option was given, my lord. And accordingly, I could not
No,
submit.
no. Who is to claim exemption?
My lord, I had to claim exemption, my
So
lord.
you are to place these documents.
My lord.
You have failed.
My lord.
Then why should this court in the year 2023 give you an additional opportunity, and now in the year 2026? You should have gone before the appellate authority. They could have done this. This court can't look into those.
My lord,
So when you have not, now are these structures, what are the structures you
my lord,
constructed?
I have mixed those, my lord, work orders.
No, it has to be in reference to that. The imposition. The imposition must have been on some show cause notice. Where is the show cause notice?
My lord, page 38.
Yes.
Let's may come to findings of investigation at page 48, my lord.
During the financial year 2016-17. So where your contracts entered into prior to that?
My
Where? No. You have submitted your reply. Let us see your reply. Where is your reply?
Page 52, Lord.
Page
52.
52.
Yes, Lord.
So you claim the exemption. Now,
But I could not submit, my lord, the work orders relevant contracts. my lord.
let's see your work orders. Where?
But it starts from, my lord, in Excerpt 6, page 158.
This note 158 is completion within 180 days.
My lord.
When did you receive the money for page 158 work?
But the bill has been received during the financial year of 2016-17. Bills has been received, my lord. Amount has been received during the period of 16-17. And that is reflected in my income tax also. my lord. Income tax.
How do I know? It is not for this court to look into it.
my lord.
Did you ask for that? That you wanted to submit those documents?
My lord.
Where? How did the officer look into, take note of your exact claim for exemption in the order?
My lord, that is, my lord, from 4.4, my lord, 206 page, my lord.
4.4.
My lord, page 206.
They observed that with regard to the contract received from the state government during the financial notice, they had not submitted copies of the work orders so and so issued by them for rendering the taxes during the day. Hence, it was not possible to know the nature of the services provided by them as well as to ascertain whether the services are exempted under IMAN. And also the noticee failed to submit reconciliation statements, working sheets, and other relevant documents to correlate the amount credited in so and so. And also the noticee failed to provide explanation, clarification supported by so and so.
Then also, my lord, 4.5, 4.6.
Further, with regard to the amounts received under the carriage contract during a year, the noticee has not submitted contract documents and copies of the invoices issued by them to so and so. Now, this order was passed when? 25/11/2022. 22. And you approached this court when?
A year,
Huh?
after a year.
But it was filed on 12/10/2023.
12/10, after 1 year. Then why?
The
Why should this court at all entertain?
problem, personal problem.
What is the problem?
My lord, my lord, the wife is cancer patient, my lord, and he was busy with her treatment and beginning. The petition. I have, my lord, stated in my petition.
Where? Where is the cancer patient's treatment? Huh? Where is the treatment? But the appeal could have been filed delayed also
Yes.
by giving a show cause, a reply sufficient cause. Why on earth should we look into this when you have not submitted and give them you an additional opportunity to submit now?
My lord, because, my lord, I am entitled exemption under the law, my.
What?
Under these two mega notifications.
No, that is subject to proof.
My lord.
You
that
have
is
not
the-
submitted any proof, admittedly.
But
Admittedly, you did not submit a proof. And they have duly considered. If you had submitted the proof, it would have been. Why on earth should this court look into all these things?
Your lordship may kindly consider that. my
I am not
lord.
going to
It is
consider.
Penal provision, my lord. But there is no finding that This,
what stopped you from submitting those documents? Nothing.
Lordship, alternative remedy is there under section 86 of Finance Act. Lordship, furthermore, page 29, paragraph 21. We kindly-
Page?
Page 29, paragraph 21. The petitioner knows that appeal lies. He said that I have a personal.
Yes, where?
Paragraph 21, the petitioner begged to submit that against the order passed by the respondent number 2, though an appeal lies to the state East Region Bench at Appellate Tribunal, Kolkata, the petitioner had to deposit 7.5% of the total amount.
That cannot be a ground.
Yes, Lordship. And regarding his inability, Lordship,
No. There was a very kind judge who has issued notice in this matter, isn't it?
yes, Lordship, Lordship, stay was not granted because Lordship, stay was not granted only because he approached the court after a year, lapse of a year.
Huh?
Stay was not granted, although prayer was made, but this honorable court make observation that since the petition is approaching this honorable court after lapse of 1 year, so interim period cannot be granted. That is also observed in the order, Lordship, while admitting the writ petition. And Lordship, this issue has already been decided by Lordship that when alternative remedy is available, then first he has to exhaust his alternative.
Here there is no question of law involved.
No.
There is no question of principle of natural justice involved.
Yes, Lordship.
Why on earth this court should look into it? There is no question that they are denying that you are not entitled to the exemption if you show these documents.
Yes.
You have not placed any documents to that effect. So,
my lord, my humble submission before lordship is that, my lord.
so you think that this court is a court by which it is just giving the benefit of certain things which have nothing to do out here.
But since it is, my lord, a penal provision, my lord, these provisions are required to be, my lord, strictly constitutional, interpreted.
No,
Yes,
Mr. Counsel, I hope you also know, I know a little bit of this law. When it is a penal provision, the law has to be strictly applied. Okay. Now, the fact that you are liable to make payment is not in dispute. What is in dispute is because of the exemption, you are therefore not liable. This is your case, which have not been. And it is also a clear and specific provision of law that when you claim exemption, you have to also come strictly within the parameters as to whether you are entitled to exemption. There is also no doubt on this principle of law. You have not provided those details. And therefore, you are not entitled to the exemption. The law is also very clear on that. So, what is your case?
But my lord, authority has to, my lord, find out whether these services against which, my lord, the recovery of payment tax is, my lord, ordered, my lord, whether these services are exempted or not. This is also, there should be a finding of the authority also.
Is
There
it?
Yes.
Show me the law. Show me the law where you are making this type of submissions. Let us hear. Show me something new has come in. Isn't that the law which has been laid down by the Supreme Court in that, I forgot, that when you are claiming an exemption, you are also to clearly come within the exemption, you have to show that this is it. This is the law. Why is he going to look into it? You are claiming exemption. If it is said that there shall be no service tax on these, then it's a different thing for him to look into it.
Yes.
But when it's a case that this will be exempted, it is for you to claim exemption.
Correct.
And when you have more particularly claimed exemption by submitting it as reply to the show cause, it is your burden duty to prove it on the basis of documents. The second, as regards the transporter, there is no quarrel with that, the proposition that it is the service provider not to pay. It is the service taker who has to pay. But you have to show it on the basis of the contract which was entered into with Calcom Cement. We didn't show anything. So why should we look into this? You think the writ court is a court of charity? No, it seems like that. The charity, they will pass any orders, whatever we ask for.
I limited is that my lord only if I get an opportunity, my lord.
You can only get an opportunity by provided you go and file an appeal. You do one thing, go file appeal. I waive this period when this writ petition is pending. Go file appeal. That is the only way out. Because in the appellate forum, they can provide you, there is a provision by which they can provide you the opportunity to place those documents, which I can't do it. That is the only way out.
Lots.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S. Kyle, who appears on behalf of the respondent numbers 1 to 4. The present writ petition has been filed challenging the order dated 25/11/2022 passed by the respondent number 3. Respondent number 3.
Three.
Whereby
Two, my lord. Two. That's one number.
What?
Two, my lord.
Principal commission.
it's passed by the principal commissioner,
Lots.
by the respondent number 2. Thereby imposing a imposing a liability of 2,27,27,960 liability of service tax to the tune of rupees 2,27,27,960 for the financial year 2016 and 17. And further, penalty in terms with section 73(2) under section 78 and section 78 and 77 of the Finance Act 1994, along with interest. The brief facts which led to the filing of the instant writ petition are that a show cause notice was issued, demand cum show cause notice was issued on 20/10/2021, alleging inter alia that the petitioner had made willful suppression of material facts to evade service tax to the tune of rupees 2,27,27,960 for the including Krishi Kalyan Cess and Swachh Bharat Cess on the services rendered by the petitioner during the financial year 2016-17, thereby violating the provisions of section 66, capital B, 67 and 68 of chapter 4 of the Finance Act 1994, read with rule 7 of the service rules, tax rules 1994. In addition to that, the show cause notice also, by the said show cause notice, the petitioner was also asked to show cause as to why penalty as well as interest as per the appropriate provisions of law should not be imposed upon the petitioner. To the said show cause notice, the petitioner submitted a reply on 15/11/2021. In the said reply, the petitioner submitted that the petitioner was a registered civil contractor and the contract receipts are from none other than the central and the state government departments. And under such circumstances, the petitioner was exempted under the mega exemption notification number 25/2012 ST dated 26/2012. In addition to that, the petitioner have also submitted, also mentioned in the said show cause reply, that as the petitioner was a goods transport agency, the liability to pay service tax is not upon the service tax provider, rather it is upon the service, upon the recipient of the service. And in that regard, the petitioner claimed benefits in terms with the notification number 30/2012 ST dated 26/2012. It was also mentioned that the petitioner provided service of transportation to Calcom Cement India Limited. It was further mentioned in the said show cause reply that the petitioner also, along with the said show cause reply, submitted the bank statement, 26 AS, audited balance sheet and profit and loss account. And in addition to that, the petitioner also informed that if any other documents are needed for assessing, sufficient time may be granted to the petitioner for submission of the same. The record further reveals that the petitioner was duly intimated by the communication dated 26/10/2022 that a personal hearing would be afforded to the petitioner on 2/11/2022 at 1300 hours. Full stop. The petitioners Mr. Counsel, I am going to impose a cost of 25,000 upon you, not to the petitioner, upon you, for filing these type of petitions. Because this is not, it is absolutely unbecoming of a counsel. Make it very clear. One page type, one page not type. How do one read it? He should also be suspended because of all these things. The said personal hearing was taken up virtually at the request of the authorized person who represented the petitioner. First. Thereupon, the respondent number 2 passed an order thereby confirming, passed an order dated 25/11/2022, thereby confirming the demand of service tax and cess amounting to rupees 2 lakh crores 27 lakhs 27,960. Along with imposition of penalty of an equal amount in terms with Section 78 of the Finance Act 1994. And rupees 10,000 as paid as and further an amount of rupees 10,000 as penalty under Section 77 of the Finance Tax Act 1994. It is also very pertinent to take note of that in the circumstance, it was that in the impugned order dated 25/11/2022, it was also mentioned that if the petitioner deposited the entire amount of service tax within 30 days from the communication of the said order, there would be a reduction of penalty to the tune of penalty imposed to the tune of 75%. Or in other words, the petitioner would only have to pay a reduced penalty of 25%. The petitioner thereupon, after almost the passage of 1 year, approached this court by filing the present petition on 12/10/2023. The petitioner have also stated in the writ petition that there is an alternative remedy available under Section 86 of the Finance Act 1994. But if the petitioner has to approach the appellate authority, the petitioner has to make a pre-deposit of 7.5% of the impugned demand. And under such circumstances, the petitioner has approached this court. First, this court have heard the learned counsels appearing on behalf. First, the materials on record show that this court had issued notice on 24/11/2023, but there was no interim order passed. First, the materials on record further the order sheet of the score of the present proceedings also show that the respondents herein have categorically submitted before this court on 16/12/2025 that the respondents would not file affidavit. First, in the backdrop of the above, this court have heard the learned counsels appearing on behalf of the parties. The learned counsel appearing on behalf of the petitioner submitted that the petitioner herein is entitled to the exemption from payment of service tax in view of clause 12 capital A of the notification number 25/2012 dated 26/2012. In that regard, the learned counsel submitted that this aspect, that the petitioner is entitled to exemption, was not noticed or decided by the respondent number 2 while passing the impugned order. And as such, direction should be issued upon the respondent number 2 to revisit the impugned order dated 25/11/2022 by permitting the petitioner to submit the necessary documents which would show that the petitioner is entitled to exemption in terms with the notification number 25/2012 dated 8/3/2007, dated 26/2012. The learned counsel appearing on behalf of the petitioner further referred to the notification dated 30/12/2012, their service tax dated 26/2012, and submitted that in terms with the said notification, it is the recipient of the service in the case when the taxable service is transportation, who is to make payment of the service tax and not the goods transport agency which was the service provider. He therefore submitted that these aspects could have been looked into by the respondent number 2 while passing the impugned order, more particularly taking into consideration that the petitioner in its show cause reply have duly claimed exemption on the basis of these two notifications. He therefore submitted that this is a fit case for setting aside the impugned order dated 25/11/2022 and remanding the matter back to the respondent number 2 for a fresh adjudication. Mr. S.C. Kyle, the learned counsel appearing on behalf of the respondent numbers 1 to 4, per contra, submitted that the petitioner had an alternative remedy. And on the ground that there is a requirement of depositing 25%, 7.5% of the disputed demand, the petitioner cannot claim that the said remedy is not an alternative and an efficacious remedy. More so, when the said provision of the pre-deposit of 7.5% of the disputed demand have been held to be constitutional by various judgments of the Supreme Court. The learned counsel for the respondents further submitted that the petitioner, by way of the present writ petition, the learned counsel for the respondents further submitted that this court would be only exercising the powers of judicial review to see as to whether on the materials available before the respondent number 2, the order so passed is an unreasonable and unirrational order, and not to sit as an appellate court over the order, impugned order dated 25/11/2022 passed by the respondent number 2. He therefore submitted that the non-submission of the documents, that he further submitted that while it is settled law that the imposition of tax has to be within the four corners of the provision, the charging section. Similarly, when an assessee claims exemption, it is the requirement of law that he also satisfies the authority that he is entitled to the exemption within the four corners of the notification of exemption. Anything more? Sure. Analysis and determination. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. The petitioner for the first time has placed before this court certain documents which should show that the petitioner is entitled to exemption in terms with clause 12A of the notification number 25/2012 dated 26/2012. Full. This court finds it very peculiar to take note of paragraph 4.5 of the impugned order. 4.4 of the impugned order. Which would show that the respondent number 2 had duly considered the notification bearing number 25/2012 dated 26/2012. And it was on account of the petitioner not submitting the required documents which should show that the petitioner would be entitled to exemption. The respondent number 2 did not find that the petitioner is entitled to exemption. Paragraph 4.4 of the impugned order being relevant is reproduced herein under page 206. Where is as regards 30?
Paragraph 4.5. Next page.
207. Huh?
207, my lord, page. 4.5 million plus.
It is also seen that insofar as the claim of the petitioner in respect to the notification number 30/2012-ST dated 26/2012, the same was also duly considered by the respondent number 2. And this aspect would be apparent from a perusal of clause 4, the paragraph 4.5 of the impugned order, which is reproduced hereunder. In addition to that, this court also duly takes note of the observations made by the respondent number 2 in the order dated, in the impugned order, more particularly at clause 4.8, which is also reproduced hereunder. এটাতে reproduce করিবা page 208 আছে. In their written statement also, written submission also, noticee failed to submit relevant documents for claiming exemption under so and so to underline. In the backdrop of the above, it is also very noteworthy to mention that it is an admitted case on the part of the petitioner that the petitioner have not submitted these documents, which would show, which would if have not submitted any documents, which would show that the petitioner was entitled to the exemptions under both the notifications. Under such circumstances, in exercise of the powers of judicial review, it would not be in the interest of justice. Under such circumstances, in exercise of the powers of Article 2 to 6 of the Constitution, this court cannot come to an opinion that the petitioner herein, that the impugned order is unreasonable, irrational, or illegal. It appears that the said order has been passed taking into consideration the materials on record which were before the respondent number 2. First, this court further finds it also pertinent to take note of the judgment of the Supreme Court in so-and-so versus so-and-so, wherein the Supreme Court had categorically observed that in order to claim exemption, the assessee has also to place the necessary materials which would entitle the assessee to the benefit of such exemption. Paragraph so-and-so of the said judgment is reproduced hereunder. Next. The petitioner have also, the materials on record as well as the perusal of the pleadings would show that the petitioner have also realized the mistake, that it was on the fault of the petitioner that the impugned order was passed. This court, in exercise of the powers under Article 2 to 6 of the Constitution, cannot direct the statutory authority to reconsider the decision on the basis of the fault of the petitioner in producing those documents. Be that as it may, the petitioner have an alternative and efficacious remedy by way of an appeal. The appeal being a continuation of the original proceedings the petitioner can very well produce such documents which would have entitled the petitioner to such exemption. Full stop. Accordingly, this court therefore disposes of this instant writ petition with the following observations and directions. This court is not inclined to entertain the instant writ petition in view of the fact that there is an alternative and efficacious remedy. Number two, this court further observes that the petition, the non-entertaining of this instant writ petition by this court shall not preclude the petitioner to prefer an appeal before the learned, before the court, before the learned,
CSET Calcutta, Lord.
to the CGAT, full name to likhi diyo, CGAT Calcutta,
186.
which is the appellate forum, wherein appellate forum against the order in terms with section 86 of the Finance Act 1994.
Lord, sir.
Number three, the petitioner herein, if prefers an appeal, comma, the period during which the instant writ petition has been pending before this court, dated 12/10/2023 till date, be excluded while computing the period of limitation, taking into account that the petitioner had bona fidely pursued the present proceedings. Number four, full stop. Taking into account that the CGAT Calcutta would be, the learned CGAT Calcutta would be the appellate forum, comma, comma. The petitioner herein would be at liberty to file such documents as so advised to show that the petitioner is entitled to such exemption. Next. The observations so made in the instant proceedings pertains to an adjudication as to whether this court would like to entertain the writ petition in view of the materials placed before this court. Full stop. These observations pertaining to the impugned order dated 25/11/2022, however, shall not prejudice the petitioner on merits if the appeal is taken up by the CGAT, learned CGAT Calcutta. Okay. What is this? Mr. J.I. Baldwin.
Now, they have respective shops, manner, the petitioner more than 100%. So, Stonen, my lord, without any, so for the, without any discussion, my lord. They have to restore the my lord, on the premises.
Now, who is there?
We are,
You are?
we are running my lord shopkeeping.
So what do they want to do?
They, my lord, want to evade my lord, and to that effect, my lord, the honorable who directed to the deputy commissioner to cause an inquiry, my lord. What inquiry findings that is not placed into record? And we do not know, my lord, what is that about, and whatever reply they have been made, my lord. It seems, my lord, the communication between the contractor and the deputy is still going on.
What right you have?
We are paying tax to the authority.
So what? Paying tax is the different thing, but what right you are having? Have you been settled with that area?
No, my lord. Is the my lord, debtor land, my lord.
Huh?
It's a, temple land, my lord. We cannot ask for any certificate.
So temple land, if you are doing any business out there,
We are paying and we are running business. That is,
you are staying there.
no, man. The shops are.
Then what right you have? You'll be put somewhere else. They want to make something else. What do you want to make?
In the affidavit, my lord, we have said that we want to develop the particular area. My lord, our project contains built up area for guest house. My lord, this is Mahamaya temple in Dhubri district. My lord, in that particular area, we want to develop the entire area for the tourist, my lord. The one guest house will be built up, one rest house will be built up, and one market, single storied market building will be there. Site development work, including development of existing pond. There is a pond. We want to develop that pond. And the related development works. But for doing the work of
And what business does these people do?
they are small they claim that they are
Into puja items, my lord.
they claiming that they are having small shops selling some puja items for the tourist. In our affidavit, my lord, we have pursuant to lordship's order, there is an inquiry. In the inquiry, we found that out of all the petitioners, only 5 number of shops will be affected because of construction of the market building. The affidavit we have filed. In the first petition, my lord, there are few petitioners, 10 petitioners. In the second petition, my lord, there are 91 petitioners.
Okay.
In fact, my lord, out of the entire petitioners and out of the all shops, my lord, the system is, my lord, the Mahamaya Mandir committee is there, managing committee is there. Some genuine shops are there. They are paying some revenue to the Mahamaya Mandir committee. The Mahamaya Mandir committee's register book, from whom, my lord, the shopkeepers, they are collecting the revenue. It shows that most of the petitioners, my lord, they are not under the Mahamaya Mandir committee. They are not giving any revenue. They are unauthorized, my lord, shops. Out of the shops, my lord, whatever is available, only 5 shops will be affected because of the construction of the market.
Why not the others?
In fact, they are outside the area. Now they are apprehending.
Now, okay, tell me, who are the 5 who will be affected?
Yes, my lord. Lordship, may kindly, there are 2 petitions. In the second petition, we have filed the affidavit.
Okay, who are the petitioners? Who are the petitioners going to be affected?
Lordship. In WPC number 953 of 25, my lord, kindly take up our affidavit. We filed the affidavit on 18/7/25.
Who are the petitioners who would be affected?
No,
My simple
No,
question is that
in fact, petitioners.
you say only 5 petitioners
No.
out of 100 would be affected.
5 shops, not the petitioners.
One petitioner, one shop.
No, understood.
No, they are out. They are unauthorized, not under the market.
No,
Not
didn't you say just now that 5 petitioners would be
5
affected?
5 shops, my lord. 5 shops. I'm sorry, my lord. 5 shops.
5 shops. But
Lord.
are these the owners of the shops or not, the petitioners?
My lord, kindly allow me to take your lordship to the affidavit, my lord. Kindly come to my affidavit. 44 petitioners. In fact, most of the petitioners are not within that area. Most of the petitioners are not within that area.
So therefore, if they are not within the area, they would not be affected.
Only on apprehension by construction of the market.
Well,
building.
in the inquiry, did you find that these petitioners are running shops?
There is no record. They claim, but there is no record. That is why, my lord, kindly come to
Let's
the.
read the inquiry.
Yes,
inquiry.
kindly come to my affidavit, my lord.
Page.
Page 66. It starts at page 64. And we filed the affidavit on 18/7/2025, my lord. Respondent number 3. 13/6.
It's a different thing. They have not done anything. They don't have any record with this register of Mahamaya Mandir committee. That's a different thing. They may be squatters out there. They may be street vendors. They may have been street vendors. But the fact remains, they are there.
My lord,
Now this land The very important question is, this land in question is a devoto land, which is permanently settled,
Yes.
and the permanently settled land, the government has no business.
But this is for development of that particular
Oh,
area.
whatever development you have is a different thing. You are carrying out a development on a land which belongs to somebody else. This is not your land. So you can't initiate 18. It's a permanently settled land of the debitor.
It is. Mohammed, not in.
I would have said, if it's a periodic patta land, it's a different thing.
No, these are not periodic patta land.
So
These are,
this is not periodic patta, it is not government land also.
Malat, this is, Malat, our entire, that particular scheme is under the under the NEC, the development of Mahamaya Mandir, the NEC has approved the construction of a market complex, guest house, rest house, site development and pond development under the component of creation of facilities for tourists at Mahamaya temple. Under that, Malad, accordingly the Department of Tourism has sanctioned the construction of work, and it is
So the
an
Department of says that, okay, we are going to make something out there.
Malad, for the benefit of
Now
the
tell me, you have a large plot of land of yours. He, Miss J, poor, she is the department. She says that, look here, we are going to make a construction on your land. And in that regard, Mr. J.I. Bhuya, who is doing the business, is affected. It is not your intention to throw him out. It is her intention to throw him out.
kindly see the Mandir Mahamaya Mandir committees, they are maintaining register. They are
Are
allowing.
you therefore espousing the cause of the Mahamaya Mandir?
No, Malad, while referring to the matter, Malad, while referring to the
On a
action,
basis. No, just for example, there might be many, just for example, in many places, like say the Kamakhya temple, is also Devatole,
Yes.
permanently settled. Now tomorrow, I'm saying, the trustees out there, they say that some of these shops out there, let us throw these people out. Who are you? The state.
but for the development of that particular area, they under any similar scheme, this development works have been
So
done.
in the name of development, then let us take the example of your land. You have a periodic patta land. The development of the thing is that a road is required to be constructed. Would you like your land to be taken up without payment of compensation?
In case of periodic acquisition and other things will come.
This is more than that. Periodic patta, the government has some say because the patta is being given by the government for a particular. But when it's a permanently settled land, the question doesn't arise. The government has no say except take some revenue. But these are also revenue-free states.
That would have been a case if Mahamaya Mandir Committee is against that particular project.
They are in favor or against.
No, definitely they are in favor, Malad. They are in favor. The petitioners.
So at their instance, you are throwing them out.
No. Kindly see, Malad. What the petitioners, that is why, Malad, I am trying to take your lordship to the inquiry report. What is the position of the petitioners? They, hundreds of persons, they come before the court. They said that if the project is implemented, but ultimately the idea is in the market area, there will be shops, and ultimately that will be given to the shop owners, who are doing business there. So what has happened, Malad? Kindly, if lordship is taking up my affidavit in the second case, para 5, we have ultimately the inquiry revealed that petitioner number 12, 17, 21, like 71, 23, 24 has a lordship got. There are 44 number of petitioners. There is no record as shopkeeper in the register of Mahamaya Mandir Committee. The aforesaid petitioners never paid any revenue, ran for their shops to the Mandir Committee, and they are not genuine shopkeepers. But there is nothing. Then, Malad, kindly see, the record available with Mahamaya Mandir Committee reveals that the aforesaid petitioners had unauthorizedly run their shops at the proposed construction site or below the staircase of Mahamaya Mandir premises. Then, my lord, the enquiry further reveals that the read petitioner number 5, 65, 73, and 74 are neither recorded shopkeepers nor any shops is
The
there.
respondent craves leave of this court to produce the relevant records pertaining to the shopkeepers
Yes,
during
yes.
the course of the hearing.
Yes, yes. This
Give me
is
the relevant.
yes, yes. My lord, this is the register they are keeping as regard the my lord. This is the register copy. They are keeping this register where the shop owner's name is there. Whatever they have paid, that those they are maintaining, my lord. That particular register doesn't contain the name of the petitioners. And in fact, this is the area, my lord, this is here, this is identified, and these are the shops affected. It would be there. No, no.
What are these type of shops? All these are new teen shops. See, I see it.
Yes, my lord. And ultimately within that particular,
These CICs must have been put in the last elections, 2024.
no, whatever is available there, my lord. Whatever is available there. Only lordship has seen the blue boundary. This is the area earmarked for the market complex. On
Which
all
one?
this, that blue color, my lord, there is a boundary by sketchpad.
So you are making a big multi-story building.
No, here kindly come to the after the photographs. The plan is there, my lord. The plan is there.
Why are you making a small one? Make a big one. Everybody can be there.
At this stage, that has been sanctioned, my lord.
So think about future. You see, why you are making out of the total 351 square meters Assam type and 121 square meters RCC.
That
Make the entire one RCC
that-
so that in future expansion can happen.
my lord is not in this particular.
Because this is not solving the problem, na. If you make a multi-story, they can also be accommodated. Yes, not those persons who are not bona fide. I'm not saying about those.
Area is too big. Area is otherwise too big, but now this project covers this area only. The blue colored area is under the particular scheme at this stage. Another project may come in future, my lord. That is not available at this stage, but subsequently it may come.
No, Mr. The problem which happens is this. For some time you raise a foundation in this area. Land is scarce now. You can't have a futuristic view. I'm saying, although it's not a part of the duty of the court, but I'm
Logic.
saying
Logic.
it's not futuristic for having an Assam type. Later on, you may have a need, but then what happens? You have to demolish the Assam type to make a via because the construction, the foundation is not like that.
That's true.
This
That's
is the problem which, in fact, we are facing in the judiciary. That is why I'm saying
Logic.
this problem is going to be faced everywhere because land is becoming scarce nowadays.
Yeah, that's true.
If it is done a multi-story building, maybe only a ground floor now is being done with a provision for another 2-3 floors,
Expansion.
then you can raise later on to accommodate more.
True.
But to have a small one only of a some type house now, later on becomes difficult.
That's true.
So, as per your affidavit, which I have read,
Hello.
it says that some petitioners have nothing to do.
No,
Petitioner number
In
12,
fact, in fact,
so
there
and
are
so, there is no record of any shopkeeper in the register of Mahamaya Mandir Committee. Okay. Now, Mr. J.I. Bordhuya, tell me one thing. You are working in the land of Mahamaya Committee, Devutar line. Now, if you are erecting shops, you are squatters. What right you have?
My lord, I have given my lord, lordship kindly see for a moment, my lord, lordship kindly see how we have been given. Just example say, lordship kindly turn to page 60.
Whose is 953 is your petition?
Yes, my lord, all the petitioner, my
Okay.
lord, I have given the.
Now
list.
kindly show
Kindly
paragraph,
see, Lord.
no, wait. Show me as regards petitioner number 12 in 953, which is the document. Petitioner number 12.
I have, next, my lord,
12, petition number 12.
for,
Petition
I
number
have
12.
given the list, my lord.
No list which you do. Tell me where is the document for that you have a shop in respect to petitioner number 12.
Puja Bodhman, Puja Bodhman.
Petitioner number 12, number 12.
What is the name of petitioner number 12?
Number 12, I have to find it.
Puja Bormon. Show me a Bormon or Govinda Bormon, whoever it is. Show me one document. How much money you have got from NEC?
In
The petitioners have been evicted.
No,
Why there is an order passed on 4/12/2024 saying that let the government council to obtain instruction regarding the actions taken by the SDO to explain why the petitioners were evicted? Why there is an order to that effect?
they filed the first petition apprehending.
Here at page 63 of your writ petition
63, just page 63,
of 953.
page 63.
and I will petition to her. Govinda Burman. My lord, Puja Burman name I have got, my lord, her father name, Govinda Burman, serial number 38.
Where?
In the UPC first writ petition, my lord, at page 28. Because, my lord, the facts that, my lord, father to son and daughter.
Page 28.
Page 28, my lord.
Where?
Serial number 38. Page number 28, serial number 38, Govinda Burman.
Where?
Page 28, my lord, in W.
Serial number
Serial number 20,
38.
38,
Okay.
Govinda Burman. It is the Puja's father. What they did, my lord, my daughter, my son, because shops are 50 years old, my lord. My father's father's father, they are running, my lord.
No, my question is Govinda Bormon a writ petitioner?
Oh, now Govinda Burman's place, my lord, her daughter's feet. Serial number, Puja Burman. What they did, my lord, they asked particular person, my lord, who died long back, her son, daughter, or
But yes, Govinda Bormon is alive.
no, my lord,
Huh?
died.
When?
When I cannot say, my lord,
You
but
cannot say, do you have not filed affidavit?
my lord, I have given a reply also, my lord, in the to that effect, my lord.
Where?
She will see
Govinda Burman conversation.
the West Burman.
What is your reply?
Reply, I said, my lord, we have not given any consent, anything particularly that, my lord. They said, my lord, voluntarily consented. We have never given any voluntary consent. And to that effect, my lord, status of the Puja Swarman, I can give, my lord, detail affidavit, if the lordship give me sometime.
What?
status of the Puja Burman. They are saying, my lord.
Oh, Mr. Borvuya, this court doesn't works like this.
No, my lord.
The matter has come up before this court, it is going to be finished.
Yes, yes, my lord.
Yes. I'm just, whatever
is-
you have made, I'm just having a thought process, how, at what time to start dictating.
This is
It
a,
is not that. Don't expect that I'm going to
My
give
lord,
time.
Even though lordship.
this particular list is a statement given by the petitioner. It is annexure 5. It starts at page 27. Kindly see para 8 of their writ petition. This is a statement made by them.
Which para of which writ petition?
Of the first petition. In the first petition,
6437.
yes, my lord, paragraph 8, they said that the respondent authorities are trying to carry out demolition without following due process of law. This has affected over 97 vendors and their families who are now facing an uncertain and bleak future. A list of 97 vendors they have given. This is annexure 5, what they are referring. This is prepared by them, not by any authority. This
Para?
para 8.
Now, tell me, are you registered with the Mahamaya committee?
Mahamaya committee, we pay the khazna.
So, no, not
Okay,
Khazna. Khazna, where is the question of Khazna? Are
They
you
did
registered with
malfunction.
them? If you are not registered, you are squatters.
My lord, I, to that effect, my lord, I have to take instruction. Whether they are registered with the Mahamaya.
No, so
committee.
therefore, we directed them to inquire with them, and who are not there and who are there, accommodate them.
Para E.
No, accommodate them somehow. And if those who are not there, throw them out.
Page 67, para E, we
Get
have said.
over.
Yes, my lord, that I agree, my lord.
Who are there
Lord,
will be
My-
accommodated.
What happened, my lord, my father.
Oh, no, father, grandfather,
and daughter,
mother,
son.
Mr. Borvuya, the fact is, one has also, this court has also, while taking up the equitable jurisdiction, also have to take note of. That you knew at the time when you entered there, that
Yes.
you are to be thrown out unless you
Yes,
have
yes,
the
full
permission.
supply Document, my lord.
Otherwise, it will be open to everybody. It will be a chaos.
Yes, yes.
So
I'll keep
therefore, we dispose of both the petitions, directing them, whom should we direct, Mr.
Malad,
SDO, my lord, it seems, my lord, he is doing favorism to contractor, my lord, as per the affidavit filed by them, my lord.
No, contractor, forget, the contractor has not come to the scene.
Otherwise, my lord,
No.
authority is the
Whom should we direct?
BTC and
the respondent number 3, Malad.
Who is he?
he is the SDO, my lord, BTC is the appropriate authority.
Who is the authority?
BTC.
Why BTC?
BTC, my lord, the
Hubli,
committee.
what is there, BTC? Mahamaya is in Sirang or Baksa?
Lordship would see page 26 for a moment. Pokrajar, my lord.
Kokrachar.
Notification are being issued by.
So why
the-
should we refer to the BTC?
My lord, committee.
No, we want one inquiry officer to look into it,
Malad,
not the authority.
Malad, for a moment. 37.
So the inquiry officer will look into it who are there and giving a hearing,
My lord, SDO.
giving a hearing to all the petitioners so that they can produce on a public hearing who are produces all these documents, and whoever fails to produce any document having a connection with Mahamaya committee payment of Priya, they are to be thrown out. Those be there, they should be kept by at the time or when the new building is being constructed, they should be accommodated.
But in fact, in para E of our affidavit, we have said that these 37 petitioners are genuine shopkeepers. Out of the petitioners, 37, after the inquiry, we found that they are genuine, they are having shops, we will give them shops. That we have said it, on page 67, we have said. Out of 100 petitioners. So that exercise has been done, Malad. And in fact, with the Mahamaya Mandir committee's record, they were heard and all of them were asked to submit their with the record, Malad.
So 9 will be affected, 9 or 5.
Only
I
five,
think-
only 5 shops will be affected because of constructions of this.
So 5
particular-
shops who are there, they would be accommodated.
Yes,
They are those 5 who are there is before this court.
Malad, pinpointedly, my instruction is that out of the 100 petitioners, if lordship comes to page 67, 37 petitioners we found that they are genuine shopkeepers of the Mahamaya under the Mahamaya. And out of those 37, or even if they are outside, if they are not here, 5 shops will be matlab, disturbed, that has to be matlab, demolished. They will be given.
But one thing, my lord,
Kindly see matlab, page 67, this 37, we are not against this 37, matlab.
But there is only 1, 2, 3, 4,
Alternative they
5,
have to give,
6,
my-
6 shops only.
The instruction said five, they said,
These 5 shops only.
these 5 shops.
So then why are all the others?
That they are
Where
apprehended.
is your shop?
my lord, in the campus area, my.
No, I'm not, we are not concerned with the campus. They have allocated a particular area wherein the
That
market
has not been
complex,
supplied to us, my.
not necessary, give you a photo.
Well, it is meant.
No, show it to you.
Inquiry
Yes, yes.
report also been not supplied to us.
Not
Yeah.
necessary. Show me the photo. You see, they are going to construct in these blue line.
Meetings were held.
In this blue line, there are only 5 shops.
1, 2, 3, 4, 5.
This is the area where it is 75% or 80% is vacant. They are constructing there. So if this is so, then in that regard, if you are having those shops out there, maybe there is the temple, there are some shops out there, they are not going to touch those. They are only going to construct in this area, which is, what is the area?
Area is Malad. This is 470 square meter. The building built up area is 470 square meter, ground floor.
No, square meters building built up would be around 4,700 or 4,900 square feet, 5,000 square feet. So 5,000 square feet is the building area, not on there. But what
Yes.
is the area of the land?
Malad,
The area of the land as it appears,
For this 5 shop, my lord, if they accommodate alternate, my lord, we have nothing to say, my.
no, you are not all to be accommodated. Only those 5 shops.
yes.
All 5 shops, my lord.
Only those 5 shops will
5
be
shops,
accommodated.
alternate accommodate, and if you can show, we can show that we have a restaurant.
No. Whether if you don't have it within these 5 shops, this is the best way.
That-
Question doesn't come.
Mr. Nath, you therefore say that the construction will be within these blue lines.
Malad.
So if it is within the blue line, this photograph shows that there are around 5 shops and only 18 or 19% of the area, total area has been only under construction. Remaining is empty.
Yes.
So therefore, these are the 5 shops which can be accommodated, not others. Matter over, simple.
Lodge.
That, my lord, the photograph submitted kept as a part of the record.
Yes.
Oh, yes. No,
Why
that-
not?
Otherwise,
Why
my-
not?
Not only that, that
Why not?
I'm making it very clear that this is the area where they are
Yes,
doing it.
yes.
And I'm also mentioning that
Apart from that, my
it
lord.
is only these 5 shops are there. They are
My-
making that.
Yes.
Apart from that, my lord.
It-
was
it is-
spent
it is-
my lord. Because, my lord, what happened in the shop area, my lord, that my grandfather, then my father
no.
died, then my daughter or son are running, my lord. That's like Puja Sharma Rosip.
Mr.
man.
Bormia, we are not going to look into those aspects,
Plus,
taking into account when they are making this construction only in this area. I know, understand that what happens that when these constructions are being made, your shop people won't go.
plus if it is so, my lord, then lordship pass the appropriate order, my lord, lordship.
So we order this only, if the construction is to be made in this, just find out, I'm coming in here, what is the area of this land?
I'll ask. And Malad, this is
And
the,
also categorically, we put it as your stand, that this is the area within the blue line where the construction would happen.
Lordship.
And it only consists of how many shops are there presently, you just find out the instruction and come back
Malad.
in these instructions.
This is,
And how many shops, rest are empty.
yes, Malad.
Right.
In
So therefore, others are not responsible. Why should we go into others? Your basic idea is you have got a grant from NEC to construct some market complex.
three,
And
four.
you want to construct this market complex in this particular area of land. And you go ahead and construct and accommodate these persons whenever is possible.
Definitely. Malad,
Lordship has
Malad-
not asked for my lord any inquiry or
Why should I inquire?
process.
He's making that
Malad,
statement.
other 3-4 works are there. Other 3-4 other works are also there. Development of pond is also there. If the development of pond in our affidavit, we have also said that if the development of pond is to be done, then 12 encroachers will get affected.
Pond is not nearby.
Pond is not here. No, pond is not here, but
Pond, they don't have a shop over the ponds.
no, near the pond, but 12 encroachers are there. If the work of development of pond is there, today or tomorrow,
That
that
subsequent will
question
come.
may come. That is why Malad, I'm indicating that if the development of pond is to be done, then 12 encroachers ultimately they will be,
What is
they will,
the
they will,
scheme about my lord?
they will-
Let him place my lord.
Sir, it is in,
It will be offer my lord now.
What,
he
what?
said part by part, my lord. Now pond, now this.
What is your
the
scheme?
scheme? Let him show.
page 39 of our affidavit. In the affidavit, we have said, page 39, scope of work,
Hope is different, assumption is different.
39.
that
Where?
is, Malad, respondent number 3 has filed the affidavit in opposition in Malad 6437 of 24.
No signature, nothing.
Scope of work,
Get to the letter.
number A, built up area guest house. Second is rest house. Third is,
Wait. 39, 38. Issued to notice to proceed with the work.
yes, Malad.
Creation of facilities for tourists at Mahamaya so-and-so under NEC for contract price. This is 11 crores.
Lordship.
Now, what is the construction?
Second page, Malad. Scope of work.
Built up area, guest house plus 1G plus AR, ground floor, Iman, first floor, Iman. Built up area, rest house for the AR and so and so. So this is the total construction which you are going to do.
We are, Lordship, now in this case, we are concerned as regard C, market, single storied building. We are concerned with that.
So the rest house and the G1 storied building.
Here it is not in question at this stage.
No, I'm asking you. This is in empty land?
Empty land. In the vicinity, Malad,
No, is it in empty land or not?
no, I have no idea because it is not questioned here. They are only challenging the market area.
We'll
Market
look
area.
into that. Market area we have come to know.
Yes,
The
Lordship.
ground floor of so and so.
So-
So you get to me the instructions as to what is the area of the land wherein you are going to construct the market.
Market.
One.
Kindly see
Second is
D.
guest house plus G plus 1 story building. Is it in empty land or under the encroachment? Okay, 12:15.
And what I have just indicated is D. Site development, including development of
So
pond.
therefore, pond to they can't have any problem.
No.
You are not nearby the pond?
But I'll take.
12:15? 12:15?
Yes.
Not nearby the pond. Let me
Got it.
come back. We are finishing the.
Inspection is that, my lord, if pond, existing pond, if they do not expand, my lord, it will not happen. Existing. Pond. If they take out, my lord, entire project works, my lord, all the shop will be next. And that's why, my lord, if we can show our document, my lord, to the authority other than the SDO. Because it seems, my lord, SDO is working on behalf of private
No.
contract.
That SDO is no longer there. She has been transferred.
Other than-
And one, no, that is an,
Let me make one small submission. Then we will continue obviously. And the 5 shops, my lord, within the blue mark, my lord, let them come. There is no, if the 5 shop is affected and they will give alternative, then no problem. If the pond or other projects or house or everything is going to build up, my lord, all the shops will be no.
No, if you have been included in the register,
Yes, valid document.
then in that regard, they will accommodate you. Because after all, it is the Mahamaya committee. This building, if it is constructed also, it is been under the aegis of the Mahamaya, this committee. It was not under the aegis of the government. The fund is being provided by the NEC to the Assam Tourism Development Corporation. so that they can carry out this construction as well as development of this area. This is the fund for which this is being done. Now thereupon, it is to be handed over to them. It is not the property of the government.
It is not the problem.
Well,
So
in
they
fact-
will have to, then they will accommodate.
Yes, my
You-
lordship will see, my
They are not parties here.
for a moment, lordship, kindly see how we came into existence, my lord, page 16
Of,
of the writ petition, my lord, first one, 6437. In the year 1963, my lord,
73.
73, sorry, my lord. May I read, my lord? This is to inform you the respected application dated so and so was placed before the general body Mahamaya Dam Managing Committee so and so general body did not agree to establish any shop in the temple. First of the general meeting agreed with the vendor wants to establish shops, then they are permitted to establish the shops below the staircase of the Mahamaya temple. Therefore, the order is thereby passed to shift all the tea stall pawn shop from the Mahamaya temple premises within 4 days, so and so. Since then, my lord, we came into existence. And authority, my lord, why I am insisting, my lord, then lordship kindly see page 26. BTC authority, my lord, the page 26 in suppression of the circular earlier notification dated so and so in pursuance to so and so executive council meeting Borderland Council 7 December 11 Department of Museum Archaeology is pleased to committee of the Mahamaya Temple Dham this so and so with the following within day-to-day affair of the functioning of the temple in the matter of utilization of the proper account so and so. And this committee, my lord, expired. It is a validity is expired now. New committee is supposed to form, they have not formed. That's why BTC came into play.
then
Then, my lord, we have got our all shops, my lord, and what instruction I have asked, my lord, that now above phone. It seems that, my lord, whoever readily available in the shop, manager, staff, employee, they ask them and they do not match the name with their list, they said so. But we got the valid documents.
now kindly come to
Last year.
page 28. Okay,
My lord,
page 28.
'28.
Serial number 38, Govinda Burman.
Yes.
Okay,
Fine.
kindly come to page 31. Serial number 88, Govinda Burman.
88 Pooja Burman, daughter, father's name is there, Gauhati.
Other's name is Govinda Burman.
Yes.
So you have put Govinda Burman there at 38 also. Govinda Burman,
Yes, yes, yes. Yes. It has
daughter, both duplicate.
two places that should not be one, either Pooja or father.
So
Any
they-
amendment will place.
More particularly Pooja.
Pooja is seems to be
Pooja's age is 24.
one.
She was not in existence when the decision was taken in 1973.
Yes, father was there.
So you should not have put both. This is
Yes,
a
yes.
duplicity.
No, my lord, maybe, my lord.
Not
they
maybe. This
I
doesn't
don't-
show.
They
This-
made a list.
Mr. D Nath doesn't want to point out this. It's a
I-
different thing.
I have taken the distraction. The guest house is complete, rest house is complete. These are already done.
So it is in free land.
It is in free land.
No problem.
Nothing will, only the market is left out.
Now pond,
Pond, one side has been developed, other side because of encroachment, difficult.
so those people, you go ahead with your construction. Now, those persons who show, because this is a committee again. The
Committee.
committee is being constituted by the BTC authorities. Where is the BTC? Yes. So this committee shall look into
Right.
the claims of those persons after the construction is done. provided they submit that they were permitted by way of inserting their name in the register.
Yes, my lord. Lordship, one copy of the register has been given to me. I have handed over the register to the honorable court. According to that register, because
I'm
in
not going to look into it. Let the authority be looked into by that committee.
lordship,
My lord,
The
is
co-
there, my lord,
that-
no forceful eviction.
that register,
No. Whatever eviction has to be done because the work cannot stop. Or you do one thing, you pay from 2024. 2 years it has been stalled because of you.
We are paying up.
No.
square meter na lage mo.
11 crores was the amount. So on that,
Can't imagine.
no, on that, put the, we say that no problem with that, not a victim, provided they keep on paying the additional amount escalation which will take place every year by then. Are you willing?
Not a pity shopkeeper, my lord,
No,
not
no.
how to imagine. Anyway, my lord, natural justice has to be there.
Heard
That is my
Mr.
lord.
J. Abolhuya, the learned counsel appearing on behalf of the petitioner, Mr.
My lord, may I leave my?
Please.
My junior brother will be there.
Mr. D. Nath appears on behalf of the, you appear for?
my lord, 1, 3, 4, 5.
One, no, you say to me there because there are different petitions, no?
Yes, my lord. In
Appears on behalf of the state government, state of Assam,
lordship.
as well as the district administration. And you are a standing counsel. Mr. So-and-so appears on behalf of 2N respond as well as the Sri Mahamaya Dham Committee because you constitute.
Yes.
So-and-so. Respondent appears on behalf of the BTC as well as Sri Mahamaya Dham Committee, which is a committee constituted by the BTC. "101 petitioners have joined together to file both the writ petitions before this court. Seeking protection from forceful eviction by the respondents. First, the materials in the court show that the Northeast Council had allotted certain amounts to the Assam Tourism Development Corporation Limited, for short ATDC, for creation of facilities for tourists at Mahamaya Temple, Dhubri, Assam. On the basis of the said, scheme, a company, namely SDP Commercial Private Limited, was awarded a contract of a value of rupees 11,35,90,000 for creation of the facilities for tourists at Mahamaya Temple, Dhubri. The period of completion, as mentioned in the work order dated 20/11/2023, was 18 months. The scope of the work includes construction of a guest house bracket G plus 1-storied building, semicolon. Construction of a rest house bracket G plus 1-storied building, semicolon. Market single-storied building and site development, including development of the existing pond. Site development work, including development of existing pond, semicolon. External electrification work and furnitures and fixtures as per the specification. The petitioners herein, in both the writ petitions, claim that they are shopkeepers carrying on the business of selling items required for puja and other ancillary items within the vicinity of the Mahamaya temple at Dhubri. They claim that they are mostly carrying on their business by setting up their shops below the staircase of the Mahamaya Dham temple, as was permitted by the Mahamaya Dham Management Committee as far back as on 6/4/1973. The grievance for which the petitioners have approached this court is that in view of the proposal for in view of the steps being taken for creation of facilities for tourists at Mahamaya temple, Dhubri, they would lose their livelihood. Though they were permitted by the Mahamaya committee to establish their shops below the staircase. Full stop. When the writ petitions, when the first of the writ petitions were filed, that is WPC number 6437/2024, on 2/12/2024, this court passed an order of status quo as regards demolition, with regard to the demolition carried out till the next date. However, subsequently, by an order dated 24/1/2025, this court, while issuing notice, observed that the status quo order so passed on 4/12/2024 shall remain limited to the 10 petitioners in WPC number 6437/2024 till the next date of hearing. The interim order, as it appears from the materials on record, have been continued thereafter in WPC number 6437/2024. However, it is very pertinent to take note of an order passed by the learned coordinate bench dated 13/6/2025, whereby the learned coordinate bench directed the Deputy Commissioner Kokrajhar to make an inquiry/survey and file an affidavit, thereby incorporating the details, particulars of such shopkeepers, the location of their shops, number of shops, if any, proof of payment of rent by the petitioners, allotment letters issued by the temple authority. It was also mentioned that the said respondents shall also file a separate affidavit bringing on record the detailed plan of the proposed market area for just determination of the cases. It is very pertinent to take note of that, taking into account that the order passed on 24/1/2025 limited the status quo order only to those 10 petitioners who were the writ petitioners in WPC number 6437/2024, 91 petitioners joined together to file the second writ petition on 14/2/2025, which was registered and numbered as WPC number 953/2025. The record reveals that in pursuance to the order passed by the record reveals that in pursuance to the filing of the said writ petition by an order dated 5/4/2025, this court issued notice in WPC number 953/2025 and passed an interim order that there shall not be any demolition of shops of the petitioners and or eviction process till the next returnable date. The interim orders so passed in both the writ petitions have been extended from time to time. The record reveals that an affidavit in opposition was filed by the respondent number 3 in WPC number 6437/2024. It is mentioned at paragraph number 3 of the said affidavit in opposition that prior to the initiation of the construction work, several rounds of discussions were held at different levels, and the vendors association were well aware of the proposed plan of the market complex and committed to cooperating with the management committee. It was also mentioned that the shopkeepers voluntarily consented to relocate their shops to a nearby place for temporary adjustment in due time prior to the commencement of the construction. And the shopkeepers also assured the Mandir Management Committee that upon the completion of the construction work, and the shopkeepers were also assured by the Mandir Management Committee that upon completion of the construction work, they would permanently be shifted to the newly constructed marketplace. Be that as it may, the construction company faced obstructions during the execution of the construction work, despite repeated requests by the management committee and the contractor. The shopkeepers did not relocate their shops from the construction site. And it is under such circumstances, intervention was sought for from the subdivisional officer civil on 4/11/2024. This court also finds it very pertinent to take note of the affidavit filed by the respondent number 3 in WPC number 943/2025, 953 of 2025. Inasmuch as the said affidavit is in pursuance to the order passed by this court on 13/6/2025 as referred to herein above. In the said affidavit, it is mentioned that an inquiry was conducted by the additional district commissioner and IC SDO civil Porbot Jora Kokrajar and the register, documents and records available in the office of the Mahamaya Mandir Management Committee. From the inquiry, it revealed what revealed in the inquiry have been mentioned in paragraph number 5 of the said affidavit. First, taking into account the said, this court finds it relevant to reproduce the paragraph number 5 of the affidavit filed in WPC number 953/2025. Page 66, 67, 67 or 68 or and paragraph number 5 and paragraph number 6, 611. From the above paragraph number 5 and paragraph number 6, it appears 44 out of 91 writ petitioners in WPC number 953/2025, there are no records as shopkeeper in the register of Mahamaya Mandir Committee. There are also no records that those petitioners paid any revenue (rent) for their shops to the Mandir Committee. And as such, they are not genuine shopkeepers. It further appeared that the writ petitioners numbers 5, 65, 73, and 74 of WPC number 953/2025 are neither recorded shopkeepers nor any shop is in their possession below the staircase of the Mandir premises. Further to that, it is also mentioned that the petitioners in number kita bhai diba 2 it ase petitioner numbers 2 3 4 it 2 it ase in WPC number 953/2025 are genuine shopkeepers who are running their respective shops there and also paid revenue/rent to the Mandir Managing Committee till the month of December 2023. It is mentioned that the authority has no intention to demolish any shops, and it is clear that the genuine shops that are required to be shifted would be allotted a site shop in the newly constructed market complex on the completion of the construction work. Further to that, it is also mentioned that the 9 numbers of writ petitioners in WPC number 6437/2024 do not have any shops located at the construction site that are required to be relocated. In addition to that, the petitioner number 2 in WPC number 6437/2024 is not a shopkeeper. Full stop. The respondents herein, the petitioner thereupon had filed a reply in WPC number 6437/2024, reiterating their stand in the writ petition. Full stop. This court have heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. During the course of the inquiry and the hearing, Mr. Dinat, who appears on behalf of the state government as well as the district administration, placed before this court 3 photographs, a site plan, of the proposed construction to be carried out for the market. Full stop. It was duly submitted during the course of the hearing that the area wherein the marketplace would be constructed is within the blue line as mentioned, as shown in the said photograph. Full stop. The said photographs are kept on record and marked with the letters A, B, C, full stop. In addition to that, the site plan which have been also placed is enclosed with the, is kept on record and marked with the letter D. এইকেইটা শুনক হোৱাইট পেজত পেষ্ট কৰি এইখন পোষ্ট কৰি ৰাখিব XYZ ABC মই যে কৈছো পোষ্ট In the backdrop of the above, pleadings as well as the documents which were placed before this court, the question therefore arises as to whether this court should interfere with the proposed construction, with the construction to be carried out in terms with the work order dated 11/2/2023 issued to so and so. আগত নামটো কৈছো ন In the previous segments of the instant judgment, this court have while taking up the affidavits so filed by the respondent number 3 have taken note of that the respondent number 3 had submitted an affidavit to the extent that those genuine shopkeepers who have to be relocated in view of the construction to be carried out would be accommodated in the marketplace.
But I have got their I have got their number. I have got their number. Four petitioners, petitioner number 26, 28, 42, and 80.
No, no, you say here, you have not stated in affidavit,
No, Lordship.
but here you are saying, na,
Yes, yes.
at
Yes.
E,
Whoever, five
you
are
are
affected.
saying that authority has no intention to demolish any shops and it is clear that the genuine shops that are required to be shifted will be allotted
Yes.
shops in the newly constructed.
Yes, that is.
Full stop. This court cannot also turn a blind eye to the fact that if there are shopkeepers carrying on business in the area, in an area which is specifically, which belongs to the Mahamaya Temple Committee, without any permission, would not be entitled to any equitable relief, taking into account that the said petitioners, said persons, knew it very well at the time of establishing their shops that they had no right to do so. First, considering this above, comma, this court therefore disposes of the instant petition with the following observations and directions. First, this court directs the respondent authorities. No, the respondent authorities herein shall be at liberty to proceed with the construction of, to carry out the necessary constructions for the creation of tourist facilities in the Mahamaya so and so. Full stop. In doing so, if there is a requirement of carrying out any demolition, the said authorities can do so. The respondent authorities are at liberty to do so. However, in respect to those genuine shopkeepers who have been genuine shopkeepers who had to be shifted or relocated or whose shops have been demolished. In view of the undertaking given at paragraph number 5E of the affidavit filed by the respondent number 3 in WPC number 953/2025, they are required, these shopkeepers have to be accommodated in the new marketplace which is to be constructed. This court further observes that in the circumstance, the petitioners herein, other petitioners herein, who have been held to be not genuine in the affidavit filed by the respondent number 3 in WPC number 953 of so and so, are in possession of documents which would show that they, with the permission of the Mahamaya Market Managing Committee, and have set up their shops and further have been paying the rent to the said committee, they shall be at liberty to approach the respondent number 3 as well as the Mahamaya Managing Committee for seeking allotment in the marketplace which is to be constructed. The respondent number 3 as well as the respondent number 3, that is the District Commissioner Kokrajhar, as well as the Mahamaya Managing Committee shall look into such grievances and shall do the needful. It is observed that in the circumstance, if these petitioners are successful in showing that they have established the shops and have also been paying the rent revenue to the Mahamaya Managing Committee, then in such circumstances, those petitioners shall also be similarly situated with the other petitioners who would be provided allotment in the newly marketplace, and accordingly they are to be also accommodated.
Space is limited, 38 shops will be there. 38 shops
No,
will be
no.
there.
So therefore, the question is this: you have come up with an inquiry. You say that they are false.
37.
No,
We found
you
37.
say they are false. 45 or 48, 50 are false.
False.
No problem. Now the question is, you are saying that these 4 or 5 are genuine out there, so these 4 and 5 will be there. As regards the others who have been relocated, whose shops have been demolished, means they are shopkeepers.
Yes, yes.
No, these are findings. They are shopkeepers. Secondly, they show that they have done it with established the shops with the concurrence of their authority. 2, 3, that they have been paying the rent dues to the Mahamaya Committee. Then they fall in the same line with the others. So they have to be accommodated. So therefore, if you have come up with a wrong affidavit, that is your lookout.
Well, that is
So I hope you stand by your affidavit.
I stand by my
No
affidavit.
problem.
30,
Then there is no
30
problem.
37 petitioners we found.
No.
And
So the 37 petitioners are not required to be accommodated. Only where you are relocating and demolishing, they
Demolished.
would be.
that's true.
But if the other petitioners are also relocated and demolished,
Then only.
but they are able to show, then they are similarly
Yes,
situated.
yes. Yes, yes.
I hope you stand by
Not-
your inquiry.
Yes, definitely. Definitely. Well,
What is this contempt matter?
the Xerox registered book, the Xerox registered book.
I don't want to.
Lodge.
I'm giving.
Oh,
I'm only keeping this one.
Lodge.
These photographs.
Malo.
Lordship, Lordship passed a judgment.
Who?
Lordship, passed the judgment in on 9/11/2023 WPC 6395/2020. And there was a direction, Lordship, the directions are on
Right.
page 22 and 23.
So the Board of Revenue directed something.
Yes, then Lordship upheld it and then directed that the FC office should do the deputy commissioner or the additional deputy commissioner should complete the process within 6 months. Lordship. But Lordship, that is paragraph 14 and 15 of Lordship here.
Yes, now?
Now, Lordship, they did not take any step. So with the judgment, we had given them the copy on 4/12/23. Then again on 16/9/2023, I wrote a letter to them.
Now, what do you want, madam?
Lordship, they have to comply with the order Lordship passed. Because on 19/1/26, it was listed, then that day they submitted that the process will be completed within a period of 2 weeks.
As possible and preferably. Preferably. Word is preferred.
Yes, preferably. No issue, Lordship. My intention is that, Lordship, it should be done. My intention is that.
No, there are hearings and various hearings are there. Accordingly, hearings in connection with re-examination of the case was conducted in so and so by issuing notice to all concerned. But it is the informed. Now, is there any dispute raised, Mr. Shah, to examine the settlement made in favor of so and so, which was originally passed by the Honorable Revenue Board dated, and this court
I do.
was given fair by the so and so? It is to be mentioned hearing the specifically in the hearing notice of the last date of AI, it was brought to the notice of in case of failure to appear on the aforesaid date, the matter shall be decided ex parte. So, he's trying his best.
Yes, Lordship.
Lordship, I do not have any,
Give it. You drop the contempt.
Lordship.
You drop the contempt.
No, Lordship, let it be pending, let them do. Lordship, last.
No, madam, I don't have the habit of putting a guillotine on somebody's head.
No, I do not.
If they don't do it, again come.
Hearing fixed on 9/2.
Isn't there a judgment recently passed by the Chief Justice B.R. Gauhati sitting with Justice Augustin Massey that a contempt, if there cannot be a contempt in a case where there is a delay, when although a time has been fixed, but the delay is not on his part, there cannot be a willful defiance. So on the basis of this document, it doesn't appear that there is he is taking up the matter on 9/2/2026.
Altogether, 8 occasion.
That day, it was fixed on 9/2/26. No notice was sent first. No notice was sent first.
No. These notice won't be appearing. Are you appearing before the court or not?
Yes, I'm appearing before.
Are you saying with all responsibility, the last order, there is no order passed that fixing 9/2/2026?
Yes,
That in case the failure to appear on the aforesaid date time, that matter would be decided ex parte.
yes, let them show that they have given the notice.
Lordship, I have that notice is still.
Is given
No,
6/2/2026. Huh?
No, we did not receive. We did not receive any notice.
No, are you appearing before in the court?
Yes, Lordship.
So there will be an order passed.
But if, since we did not receive.
No,
the
madam, the question is whether you see, this notice cannot happen like this. This notice can happen on the basis of an order in the records. So are you appearing in the proceedings or not?
hearing, when
Now, what had happened on the last date on last date when it was fixed?
last date, Lordship, the other party did not have to, when I appeared, Lordship, the other party did not appear, then they said they will be fixing a date, then the ADC had an accident. He, over telephone, he told me that he has broken his leg or something, so he is unable to do the thing. I have the telephone records.
Then
And after that, no date was fixed. Then it came up before the court on 19/1/26. They said ki within 2 weeks they will be doing something, and then they did not send us any notice.
no, you were present on 19/1/2006.
Here. In the court. In
Here?
the court, yes.
No, what about there?
Their lordship, after last we appeared, they did not send any more notice that we have to appear. They did not fix any
So
date.
are you saying that these dates are not fixed?
No, these dates, some of the earlier dates were fixed, lordship. Till 25, this 26 date is not fixed. No.
Huh?
No, lordship, 15/9/2025 date correct, but 9/26 date was not fixed on 15/9/2025. It was not fixed.
So the
When
next,
I appeared on 15.
okay, the next date is on 9/2/2026.
Yes, that was not fixed.
There is a date.
There was no date on that.
As
date.
of now, madam, you know that there is a date.
Okay,
Go there.
but lordship, today is 10. They have fixed it yesterday.
What happened on 9/2?
Nobody turned up, Lordship.
Who is this ADC, Commissioner Kamrup? Then did you
ADC,
pass an order?
ADC,
Did the ADC pass an order on 9/2/2026?
no such order because they have last line, Lordship. They will take some decision.
Let us hear him at 4 o'clock. 3:30, 3:40, 3:40.
Regarding whether he has passed any
What
order,
happened on 9/2/2026?
Lordship, on video conference, Lordship.
Or
4
2
o'clock,
o'clock?
Lordship.
2 o'clock, let us see him and ask him what has happened. Or you want to get the instruction, what happened on 9/2/2026?
Lordship may kindly give another date. I will.
No, it cannot happen.
But I'll
Today
obtain
the matter
instruction.
has been fixed.
I'll obtain
You
instruction.
say, please note that in case of failure on the aforesaid, the matter will be decided ex parte.
Yes,
So
yes.
therefore, on 9/2/2026, both the parties did not appear. There's no problem.
Yes.
So the order has been passed or not?
No, perhaps not, because Lordship last line, they have sought some 25 days more time to take a decision. Last line of my instruction, Lordship.
Ah,
Office will take an expedited decision within 25 days of time. So it seems they have not taken the decision. Because ultimately, Lordship, if nobody turns up, Lordship, that the district commissioner has to take a decision upon considering the material on record, Lordship.
no, you see, there is already an order passed by the Board of Revenue.
Revenue, Lordship.
This court confirmed it and said that, okay, you take up this matter out there
Yes,
and decide, because I can't pass that consequential order.
Lordship.
This order was passed in the year 2023.
23.
We are in 2026. Does
Six.
it look nice?
That is correct, Lordship. But Lordship, that record goes to show there altogether 8 dates were fixed for hearing. So,
You produce the order sheets
Lordship,
of these dates which are being mentioned here,
Lordship,
as well as yesterday's order sheet,
Lordship.
or the order sheet since 26/12/2024 in this case,
Lordship.
before this court next Wednesday. Today is Tuesday, next Wednesday. Okay,
On 18,
11th,
11, sorry.
not on 11th, on 18th. Okay.
18, Lordship.
The instant petition has been filed alleging willful and deliberate violation to the order dated 9/11/2023 in WPC number 6395/2010. It is mentioned by pursuant to the said notice being issued in the instant proceedings, no affidavit has been filed by the contemner till date. Be it as it may, an instruction has been placed before this court dated 9/2/2026, which is kept on record and marked with the letter X. From a perusal of the said, it appears that various dates have been fixed right from 26/12/2024, so that the directions so passed by this court dated 19/11/2023 can be complied with. It appears that more than full stop. Accordingly, list this matter on 18/12/2026 at 2 p.m.
Lordship.
Mr. S.R. Burwa, who represents the respondent, shall produce the order sheet of the said proceedings, which should show the orders passed therein since 26/12/2024 till date.
Otherwise, Lordship, new incumbent has joined. I have not. Otherwise, Lordship, in this case, new incumbent has joined DC as well as the
I'm
ADC.
not concerned. Let
Lordship.
us see what has happened.
My intention, Lordship, is that the work should be done. That's
Yes,
what-
even even I am also
Let
trying.
us see.
Yes,
You may get the order even before 18th. That is why I'm fixing.
hello.
So item number 8 is my next item. So the bank has brought the record. We may be allowed to inspect it from here.
Speak.
Well, this is that tender matter, the SP Singla matter regarding the North Frontier Railway tender. My lord, the item 4 and 5, this is that tender matter where we had put in our bid. Acha. So my lords, we had led arguments, my lord is well aware, my lords had asked me a very specific query regarding the locus to challenge the tender condition once I have participated. My lords had also recalled the Jhansi Expressway judgment wherein I only get the right to challenge the condition once I've participated. If I've not participated, I don't have any locus. My lords, one very important clarification also which is required is that we had filed the petition before participating. So last date of submission of bids was 27th of August. I have the filing details herein. If I may just pass it on to.
I'm sorry, Mr.
Just mentioned that we filed it on 26th.
Huh. May it please your lordships. My lord, if your lordships would kindly come to page number. Yes, page 139, my lord. This is the result of technical bid evaluation. Now SPS is the petitioner. Action rejected. Why? Non-responsive as per clause 2.2.2.2 and clause 2.2.2.4322 of the RF. Now, my lord, possible kindly come to page number 101. The bidders, 2.2.2.2, the bidders shall have a minimum net worth of amount equal to 5% of the estimate. Okay. Then, my lord, 2.2.2.4, which starts at page number 101. My lord will kindly come to page number 202 towards the bottom of the page. That is now the bone of contention. There should not be history of collapse of superstructure, structure of any span of a bridge, flyover, viaduct, metro line work during construction service in the last years ending the last day of the month previous to D1 in which the tender is invited. Undertaking in this regard shall be submitted along with the bid. Now, my lord, before I make my argument on this, my lord, since this writ petition was very hurriedly filed, a particular clause could not be brought in here, my lord. For that, I'll trouble your lordships with the other writ petition, my lord. Ekhon dibo na? 50512. My lord will kindly come to page 132 for a moment. This is the same clause 2. There should not be history of collapse of superstructure, substructure of any span of a bridge, flyover, viaduct, metro line work during the construction service in the last 5 years, ending the day of the month of the previous to the one in which tender is invited. Now, my lord, this 5 years was brought down to 3 years to facilitate the bid of the respondent number 3. 3. Now, what happened, my lord? There was a pre-bid meeting. That lordships will find at page number 148. Serial number 22, my lord. Additional experience, history of collapse. Now, original clause reads like, decision of the above clause 2.2.2.4322 or modification as there should not be history of collapse of superstructure, structure of any span of a bridge, flyover, viaduct, metro line work during construction, service in last 2 years, 3 years, ending with the day of the month previous to the one in which the tender is invited. So this was the original clause, Miller. It was the suggestion of the bidder, Miller. Yes. Yes. Absolutely. Now, my lord, next column. Yes. 5 years. Yes. Correct. Correct. No, not only that, the right hand side column is important, remark is important. Now, I understand, my lord. Yes, yes. Clarification has been incorporated in the revised RFP. Collapse of superstructure, substructure pertaining to design failure or quality related failure of permanent structure would be considered in this clause only. So this clause we do not find place eventually.
At page 99, now what stands in the, what we find from the NIT is at page 99. So this is what was suggested, my lord. So where is the legal certainty? How do you know, my lord, how it is going to be operated? Now, my lord, the use of the expression permanent structure makes a lot of difference. My lord, the ongoing project in which there was a collapse in our case, that was not a permanent structure. The clarification has been incorporated in the revised RFP. Yes. Yes. No, Mila, there is no form for the undertaking. No form prescribed for the undertaking. That's very important in this case. Yes. Now, Mila, now Lordship will kindly come to page 99 of this writ petition. This is what eventually, my lord, finds place as subclause 2. There's page 99, last portion towards the bottom. There should not be history of collapse or superstructure, substructure of any span of bridge, flyover, viaduct, metro link, line work during construction, service in the last 3 years, ending last day of the month of the previous student in which the intender is invited. So, my lord, what was asked, the clarification asked for and clarification provided do not find place here. Now, end of the day, my lord, whether they were insisted on collapse of a permanent. Yes. No, my lord, there is one issue. If your lordship will kindly come to page number, now I'll leave it here, this petition, my lord. Now I'll. Yes. Yes. No, my lord, no, that's what, my lord. Actually, there is a scope of, my lord, seeking clarification. Clarification wala 117 tha nahi kya? Yes. No. Just 1 minute, my lord. 124 nahi kya? 114. Huh? 114. No, please come to page 117, my lord. वो लिखा क्यों नहीं यार 117 है रुको ये तो क्लैरिफिकेशन है page 117. Now kindly see, my lord, heading evaluation of technical bid to facilitate. Now I'll trouble your lordship within that is 6625. Lord, I refer to that petition only for that limited purpose of, my lord, referring to the pre-bid meeting. Otherwise, other documents are here. Page 117. Now the chapter itself deals with evaluation of technical bid and opening of evaluation of financial bid. Please come to 3.1.4. To facilitate evaluation of the technical bids, the authority may, as its sole discretion, seek clarification in writing from any bidder regarding its technical bid. Such clarification shall be provided within time specified by the authority for this purpose. Any request for clarification and/or clarifications in response thereto shall be in writing. The bids will be examined and evaluated in accordance with the provisions set out in section 3. The authority will subsequently flag issues, if any, with the data updated by the bidder. If a bidder does not provide clarification or above within the prescribed time, his bid may be liable to be rejected. Power is given to the employer, my lord, that if once clarification is sought and it is not provided, then your bid can be rejected. Now, my lord, since this particular clause 3.1.4 finds place in the heading of evaluation of technical bid and opening of financial bid, my lord, although the expression may is used in 3.1.4, in my humble submission, my lord, it has to be read as shall. Now, because more particularly, having regard to the language of that particular clause, 2.2.2.42, it was incumbent. Moreover, kindly see our Milord undertaking. Because as I've already submitted, there is no form prescribed for the undertaking.
No. My question therefore is, in the undertaking so submitted, did you say that it was not a permanent structure? Or
Yes.
had nothing to do with the design?
Yes, I think if your lordship will kindly permit me, let me place that undertaking, my lord. ना बड़ा list of date नहीं बनाना चाहिए. Yes, page 124. Thank you.
Yes.
Now, my lord, the very submission was without prejudice to our rights. Now, lordships may kindly come to the third subpara, where we refer to the my lord particular clause, then how we responded. Subject to the foregoing, it is disclosed in respect of unforeseeable collapse of part of span on 3422 and 4623 in respect of Sultanganj Awani Ghat project under instruction of the employer therein and as per order dated 14/9/2023 of the Honorable High Court of Judicature at Patna under PI number so the re-execution of collapsed part of span work by bidder is in progress under the force majeure clause 221.6 read the contract agreement as a whole. Finally, the matter in respect thereof is to be resolved within the modalities of the contract agreement therein as a whole. Accordingly, the undertaking is given. This undertaking is without prejudice to all the rights of the bidder, including to avail all constitutional remedies, interim relief, simultaneously to prevent possibility of declaration of non-responsive status to the bidder by the doctor so by the competent authority. This is how I responded. And
But you have not stated that the collapse of the superstructure or substructure pertains to design failure or quality related failure of permanent structure.
Now, my humble submission in that regard would be, or that I rely upon the judgment of the Supreme Court in the Reliance case, where the Supreme Court has, my lord, carved out concept of legal certainty. Now, my lord, kindly see. In a sense, this particular clause has an element of blacklisting also. Because, my lord, without any hearing, without getting any opportunity, bid would be rejected. Thereby, my lord, I am not liable to take part in selection process. Now, my lord, once there was a pre-bid meeting, and in the pre-bid meeting, a consensus was arrived at, whereby they would rely upon, my lord, basically a project which is completed. If there is a collapse of a project which stands completed, then there will be should be different. But that is not the case here. Now, are you not playing hide and seek, my lord? Therefore, that principal argument of my lord, that legal certainty comes in. Kindly see the consequences, my lord. For the manner in which you have exercised the power, manner which you have couched the language of this particular clause, there is every scope of misuse. There is every scope of the people will be, misled by it. So, had it been.
Therefore, there is a clarification given.
Therefore, given, they have not sought for clarification.
No, there is already a clarification given as regards the collapse of
What
the
I'm saying
superstructure
is,
pertains to design.
after my undertaking, if they had any issue regarding understanding what is the purport of what we are saying, they could have always asked for it, which they have not done it. Under that clause 3.1.4 at page 117, my lord, there was a duty cast because that is a provision for a heading of technical evaluation. So in the process of evaluating my technical bid, if you are finding anything, any I mean, the difficulty in appreciating or understanding what we wanted to convey. The clarification would have clarified. Now, the clarification would have also given me an opportunity. They would have complied with the principles of natural justice also. In that case, my lord, they could have said, this is how this the view want to take, this is your undertaking, what do you say? Then we could have explained the things. We could have explained the things which I have argued today. That in the on 85, there was a consensus decision arrived at to have this particular clause, which we do not find. Only reducing that 5 years to 3 years, nothing has changed. And 5 years has been reduced because to help the respondent number 3, because there is a case of collapse of respondent
No,
number
no,
3
I
within 5
think-
years.
No, therefore, in page 132 of the earlier petition, they had put 5 years. Therefore, I say the second, when the clarification is being sought for,
Was 2 or 3 years.
2 or 3 years, meaning thereby it was, must have been, another clause must have been put somewhere, somehow. Otherwise, why the query would only, did not mention anything
No,
about
that-
5?
That prima facie, that
So therefore, it is 2/3 years when the query was being raised. Then they gave an explanation that look here, if it is a case only for collapse of the superstructure pertaining to design failure or quality related failure of the permanent structure, then only it would be rejected in this clause, otherwise no.
not.
So this is a clarification. So when this clarification is there, if you,
Then if we accept that to be clarification, then that my lord rejection is arbitrary.
why?
Mine is not a case of design failure or a permanent structure having been collapsed. It's an ongoing project. If that is the
But
position,
did you mention anywhere to them that look here, mine is not a case of that?
no, my lord, it isn't. It is everybody's in the writ
No,
petition,
when
there
you
are
have
things.
when you have that clarification given on 18/5/2025,
No. Writ petition, there are pleadings.
I'm not here. Before the authority, did you say, or even in the undertaking, did you say that it has nothing to do with collapse of or design failure
we
or
have
for
said, my lord,
permanent
under
structure?
the force majeure clause of that particular contract, undertaking the repairing work. So that means, my lord,
Mr. Chaudhary, you also know, I also know what is the order passed by the Patna High Court. The Patna High Court did not go into those, saying that, look here, he has said now he is going to again reconstruct it. So we let him do his constructed and he'll complete it.
Yeah.
They didn't go into the question as to whether it was the fault of yours or the fault of anybody else.
no, that my humble submission is it the case of the NF Railway now that it is not a case of a design failure or it is not a case of breakdown of a permanent structure? That it is a case false which no, that is not their case, my lord.
No,
They
you
simply refer to the clause.
No, Mr. Chaudhary, if you would have said that it is not the case of design failure or a failure or anything to do with a permanent structure, if they then say no, it is, then this is for this court to look into that.
No, my lord,
But it is not your case.
Assuming, my lord, assuming that aspect at that stage. But in the writ petition, we have taken the clear stand. To that, the affidavit is silent.
But Mr. Chaudhary, I am here sitting in judicial review.
No, I appreciate. I'm not saying that. All that my lord, my humble submission is, in view of the, my lord, consensus which is derived in the pre-bid meeting, and our natural understanding was it is not a case of a design failure, number one.
So why on earth didn't you put it in the undertaking that it is nothing to do with the design failure or it's not a permanent structure?
No, we were under the impression since there is a clause.
Only one line would have been gone enough. Only one line.
Correct. No, that would have made things easier for us, my lord. But even now,
if you would have, then you bring that aspect within the powers of judicial review to look into it as to whether they have looked into it or not.
no, even now lordships can do that.
That is very difficult.
They are not referring to anything. All that they're saying is clause so and so. At least, though there is no requirement of passing a detailed speaking order, but they must indicate, my lord, on otherwise, my lord, is it not a case where, my lord, there is no legal certainty? So can I place the judgment on legal certainty, my lord, which is important in my case? Reliance wala do to. 2007, 8 SCC, page 1.
Tag eta dibo na? Tag. Yes.
My lord,
Please, Martha.
the operative portion at page 22. Tenders are invited. The terms and conditions must indicate with legal certainty the norms and the benchmark. This legal certainty is an important aspect of the rule of law. If there is vagueness or subjectivity in the said norm, it may result in unequal and discriminatory treatment. It may violate the doctrine of legal I'm heavily relying on this passage because of what transpired in the previous meeting and what eventually we find in the Millard eventual clause 2.2.2.4322 is Millard, we are at a loss. So therefore, Millard, since ours was not a case of collapse of a permanent structure, therefore we submitted the undertaking. And if they would have prescribed any form for the undertaking, things would have been different. There is no form for the undertaking. So it is in this context, Millard, if my technical bid is to be rejected on this ground, will it not amount to, Millard,
What you have
denying me
stated,
the legal playing field?
what you have stated in the undertaking is this.
Yes.
The qualification required under the clause so and so, read with the remarks in previous meeting, the clarification has been incorporated in the revised so and so is patently ambiguous, unenforceable and merit declaration.
Yes.
As being void by Article 29 of the Iman and being violative of Article 14, 19 and 21 and 32 of the Constitution. 32 obviously won't come.
Yes, yes.
So therefore,
No,
my question is,
no,
why
Lordship
on
has posed
earth
that
there is
question.
not a single statement made
Yes, yes.
that it has nothing
Please,
to do
please
with
come to
common.
third subparameter.
Yes.
Undertaking at page 124. That the qualification requirement under above referred clause 2.2.2.22 read with the remarks in reply to the previous query being clarification has been incorporated in the revised RFP. The collapse of superstructure, structure pertaining to design failure or quality related failure of permanent structure would be considered in this case only. It is patently ambiguous, unenforceable, and merit declaration as being void and under section 29 of the Indian Contract Act also being violative of so and so, so and so, so and so. Taken that plea, Mr.
No, you have not taken that plea. You are saying that clause is wrong, but you have not taken the plea that it has nothing to do with design or patent or permanent structure. Where is that statement
in
to the
so many words, it was not there. Lord, when Lordship expects that a bidder has to follow the norms, it is the same principle applied to the employer also. Because in the Dharam Satish case, para 11 Supreme Court has said, my lord, the employer is as much bound by the terms and conditions. If they do not follow, then they will do it at the cost, at their own cost. Now here in this case, my lord, as a bidder, was I not prejudiced, my lord? Yes, I was prejudiced because the rebid meeting decision says so something, and my lord, the clause 32 as finds place in the main tender, my lord, it reveals something else. Therefore, what would be the position, my lord? So therefore, it's a clear case where the level playing field was duly denied to the petitioner. And also take note of one thing, my lord. An ongoing structure and permanent structure, these are mutually exclusive, my lord. Ongoing, it denotes something else, permanent denotes something else. So, my lord, in such a situation, was it not a case where the para 38 of the Reliance decision would apply, my lord? Kindly see, I am a bidder, my lord. End of the day, my lord, the legal niceties are not, they're not the bidders, expert in technical and other field, my lord. They're not, it is not expected that they will know the legal niceties also, my lord. So, end of the day, To evaluate, my lord, what your lordship should see is whether there was a bona fide effort on the part of the bidder or not.
I would have seen in respect to these panchayat matters, I would have looked into. But when we are concerned with matters pertaining to thousands of crores, I think you have the good legal backing.
So at that
But
stage,
but we have. I also doubt that your legal backing may not be proper, taking into account you say it to be violation of Article 32. Okay, let us come to the next. I have understood your point. Your
Your-
point is here,
yes.
if I may just encapsulate out here, is that this particular clause, which is there,
is capable of understanding in a two to three different ways. So therefore, my lord, to analyze somebody and that the understanding of the employer in this regard is the only understanding, that may not be correct. Therefore, all these line of decisions that the employer's view is correct, that may not apply in this case.
how do you take care of two judgments, Afcons and Jagdish Prasad?
No, my lord. Yes, my lord, here is a case, my lord, end of the day, Article 14 has to be complied with, my lord. And Article 14 has separate components, my lord. So here in this case, if there is arbitrariness, has corrected in the decision making process, then certainly, my lord, they may not have the bad intention. But end of the day, if it so transparent that the decision making is fraught with arbitrariness, then yes. Article 14, for example, what was said in Alia, whenever there is arbitrariness in the state action, Article 14 springs into action. It is also said, my lord, state is not bound to enter into a contract. But if state decides to enter into contract, then they must fulfill Article 19 and 14. So therefore, these principles are there. Now here in this case, my lord, I am such a party. Presently, my lord, I am under the same NF railway, my lord. I am constructing that bridge, Jorhat Mandali bridge. My lord, this Jogigopa second bridge, I have completed more than 60%. Then, my lord, now that one elevated corridor is coming up of about 1200 crores, that has also been given to me. That's not very obscure, my lord, when on a very flimsy ground, my candidature is sought to be rejected, my lord. And I have otherwise very successfully carried out all these projects. So to say,
That cannot be a ground for this court to exercise judicial review.
all that I am saying is, it is the same employer who has found me suitable, and they did not
Now,
consider.
did they have the same clause in that matter where NF Railway has done, and then they have taken a different decision? If
Yes,
just for example, in the case of Rana Construction,
Yes.
when I was dealing with two matters, one was a matter pertaining to Rana Construction, and then there is another matter which has been done by AIA, where the PWD authorities were using different yardsticks for applying this particular very same clause. And then I took up one matter and disposed of together. Is it something to the effect? Can you argue on that aspect?
My lord,
If you can, on the similar clause was there, but in that clause,
no, my lord, this is one aspect. Now the other aspect is, my lord, can I be denied a right of participation in the further processing of the tender by virtue of this clause?
isn't it that if you don't qualify in the technical bid, you cannot go ahead with the financial?
Because my cancellation of the technical bid is on account of this clause. Now there are decisions of the Supreme Court, my lord. We say you cannot apply such for this. I'm coming to that. That's the second limb of my argument, my lord. Now, eventually, my lord, the effect is I'll be blacklisted. Now, read the blue drink. Fifteen SCC 264. 2020-15 SCC 264. Milord will kindly come to page 20, para 26.
Yes.
Milord, I'm sorry, Milord, I may be permitted to read para 25 also.
Hmm.
What is significant is that while setting out the guidelines prescribed in USA, the court noticed that comprehensive guidelines for debarment were issued, therefore protecting public interest from those contractors and recipients who were lack business integrity or engage in dishonest or illegal conduct or are otherwise unable to perform satisfactorily. The illustrative cases set out also demonstrate the debarment as a remedy is to be invoked in cases where there is a harm or potential harm for public interest, particularly in cases where person's conduct has demonstrated that debarment as a penalty alone will protect public interest and deter the person from repeating his actions which have a tendency to public interest in jeopardy. In fact, it is a common knowledge that in notice inviting tender, any person blacklisted is rendered ineligible. Hence, blacklisting will not only debar the person concerned from dealing with the concerned employer, but because of the disqualification, their dealings with other entities also is prescribed. Even in terms of the terms and conditions of tender, terms and conditions of the tender, in the present case, one of the condition of eligibility that agencies should not be blacklisted from anywhere. In other words, well, the case is of an ordinary breach of contract, an explanation offered by the person concerned. There is a bona fide dispute, blacklisting debarment as a penalty ought not to be resorted to. Debarring a person, albeit for a certain number of years, amount will death, in as much as said person is professionally ostracized, resulting in serious consequences for the person and those who are employed by him. Too readily invoking the debarment for ordinary cases of breach of contract, where there is a bona fide dispute, is not permissible. Each case, no doubt, would turn on the facts and circumstances of each case. Milord, I am trying to draw some support from last paragraph, Milord. Here in this case, Milord, in the attending facts and circumstances, I am sought to be debarred from further participation of the tender on the ground that has taken place in this particular project which I have undertaken. Now, Milord, in what situation it happened, why it happened, I never had the opportunity to explain to anybody. Will it not have a bearing, my lord? End of the day, my lord, because there was a collapse, therefore I am sought to be, non-suited. Would that be permissible, my lord? Will it not amount to civil debt? My lord, exactly on a more or less similar set of facts.
On a lighter note, Mr. Chaudhary, when I was practicing in the bar,
Yes, my lord.
and when I was there, I would always remember you making a submission in the court that the judgment has to be seen on the facts of each case.
Correct.
And here the facts are different. The facts are there was a tender was issued again to this particular dreamage and so, and when this tender was issued, there were certain amounts of dues which are being pending. He therefore, this company therefore requested the payment to be made. They did not make the payment. Then he raised the dispute. This led to they issuing a newspaper ad that look here we have blacklisted him for so and no work is to be given in the city of Kolkata. Then the matter comes out that look here, I have been blacklisted in this manner, and this is in the circumstances where paragraph number 20 to 24.
Absolutely correct, my lord. Lordship even knows the facts, but my humble submission is kindly appreciate, my lord. What I am trying
What
to
you are
say
submitting, Mr. Chaudhary, if we say anything to that effect, it will have a lot of problems in finalizing in each case where it is the settled principle of law and it is the tender condition. Once you qualify the tender condition, the technical bid, your price bid. This clause is there also in the tender conditions. If that be so, then unless you challenge that condition, how can I look into that aspect?
Question is reading of the clause 2.2.2.4322. Is it possible to come to only one conclusion? And have more particularly having regard to the consensus arrived at in the pre-bid meeting.
You have referred to section 29 of the Indian Contract
Contract Act.
saying that a contract is void or is uncertain
Yes.
is void.
Right.
This is-
That's what legal certainty meaning what, Miller?
So therefore, you are saying that you have violated, it is ambiguous and as such violation of Article 29, Section 29. Now, if there are two possible
If there are two possible
views,
then lordship
the
will not
views which is being accepted by the owner has to be accepted as per Afcons and Jagdish Prasad. But if no views is at all been can be ascertained by them, what they have is wrong. What you are saying it may be a possible thing. Then it is a case of 29.
Submission is, I'm not meaning that a big, a very lengthy speaking order should have been there. At least, my lord, while saying that rejected on account of non-conformity to clause so and so, this aspect was not followed. Then that would have given your legitimacy to the decision making process. Kindly, my lord, now the work has been given to a party 5-year. We have given documents to show that 5 years they have the problem. Now they have overcome that because insofar as that 5 years is there, it has been brought down 3 years. Now, when we look at the scenario, what is clearly evident is a very clear picture doesn't emerge. Therefore, my submission is, my lord, it's a case where level playing field was denied to Krishna. More or less similar situation was there by Delhi High Court. The judgment will kindly permit 2 paragraphs. Lord, this is Atlanta Limited versus Union of India. For the facts, my lord will kindly come to paragraph 7. And for the other operating portion, I will have your lordship's kind attention to paragraph 25. 2.1.18. Any entity which has been barred by Ministry of Road Transport and Highway or its implementing agencies for work of expressways, works, and the bar subsists as on the date of application would not be eligible to submit the bid either individually or as a member of the joint venture. So this was the Miller clause. Bidder including individual or any of its joint venture member would in the last 2 years have neither failed to perform for the work of express ways, national highways, ISC so and so, as evidenced by imposition of a penalty by an arbitrator or judicial authority or a judicial pronouncement or an arbitration award against the bidder, including individual or any of its joint venture, as the case may be, nor has been expelled or terminated by Ministry of Road and Highway in implementing the agencies for bids by such bidder, including individual or any of its joint venture member. Then Milord now will kindly come to the para 25. This was the clause. As a result of the discussion above, it is held that clause 2.1.19 of the tender condition is arbitrary and unreasonable to the extent that in the matter of a case falling under the said clause, it amounts to automatic debarring of the party from participating in any other tender taken out by NHAI for a period of 2 years without a hearing. The condition is therefore held to be applicable in other cases of termination, if and only if NHAI or public agency affords the party a right of hearing in such debarment. And second, this debarment from participating in another tender due to termination of tender case shall be justified only after considering merits of each case with respect to such other tender. The court is also of the opinion that such a wide debarment condition is disproportionate in that it directs authority to rule out absolutely consideration of tenders and bids for a period of 2 years. Termination of contract can be for various reasons. They may be at the beginning of the contractual period or at the fag end of the competition completion period. Given this variation, treating all contracts alike in regard to the result of debarring the private parties who might not have caused any or at least not caused substantial injury to the NHAI interest results in arbitrariness. Lord, because a contract can be terminated or done away with at different stages, my lord. So therefore, to equate all is, my lord, difficult to comprehend. Now, the principle of law in my humble submission, my lord, which is deducible, is that in a case where, my lord, it's something like, my lord, Rule 18 of our Assam settlement rules, where it says, if there is a bona fide claim of right, you cannot readily invoke any summary procedure. So in the process of determining my technical eligibility, you were not only disqualifying me, you were also holding me guilty of something of which there is no, my lord, examination. So it is a double-edged weapon, my lord. On one hand, I am being victimized, I am being characterized as a person involved in, collapse, when the authority under whom that collapse, they have not construed me as such. The authority under whom I am working, they have still permitted to go ahead with the work. In such a scenario, my lord, to construe me to be a person guilty of collapse and consequently to cancel my bid, my lord, I think it is too much. It's too much of arbitrariness. So, my lord, this is not a very big matter, my lord. So to sum up, my lord, my argument is very simple. My lord, kindly see, the manner in which they have dealt with my tender in respect of 2.2.2.2, will it not show, my lord, malice in law? Because I submitted the bid on 22/8/25, on that day my audit report was not ready. So, my lord, for the current year, when the requirement is only 75.48 crore, whereas I had a turnover of 1200 and odd crore, they rejected my tender. Whereas, my lord, as per the tender clause itself, in such a situation, what I was supposed to do, I am to give the balance sheet for the previous 4 years, 5 years, which I have given. And for the next year, my turnover is 1300 crore against the requirement of 75 crore. So they have rejected my tender on that ground only. Whereas the same railway, my lord, applying the same terms and conditions in another tender, I was, my lord, my case was considered. However, I became L3, therefore the work could not be given to me. So are these not suggestive of, my lord, an action which is not in conformity with Article 14?
Wouldn't the doctrine of severance will apply here? Whereby if one decision may be wrong on one side, but the same
Lord.
decision can be upheld
No,
on the basis of another. Yes, can this court?
No, my lord, all that I was trying to submit is just to show, my lord, the malice in law involved in this.
The malice in law is there in
Yes.
respect to 2.2.2.2.
Yes.
There's no quarrel. So therefore, I've not asked you also
no,
to argue on that.
No, my lord, just to oust me, they have taken reverse to a measure which is out and out not permissible, my lord. So does it not show something, my lord? Will it not count as a, my lord, point to be taken in my favor when eventually your lordship takes a call on the issue?
You may,
Therefore, my lord,
you may also submit that taking into account that there was a matter pending before the court and the court had directed them to consider your case.
Yes, I was about to come to that, my lord.
To consider your case. So they, instead of therefore to come up later on and say, hey, look here, forget about this. In 2.2.2 also they are disqualified.
No, my lord, that was my third point, my lord. This honorable court, despite, my lord, when I apprehended that my future, I approached this honorable court. This honorable court gave an interim order which was never vacated until the tender was, my lord, finalized. The direction was consider the case subject to outcome of this case. So duty on their part was to consider my case and keep it in a seal cover. Maybe that's a different. The end of the day, when the lordship takes a call on the merits of that particular clause, then only the tender could have been finalized.
But the problem arises because of the order passed by Justice Majumdar. If you would not have, if you not come up before the court with that application, he couldn't have passed that order.
Anyway, my lord, the four broad points on which my petition, my lord, rests.
So your point, if I may just
Yes.
sum it up. First is clause 2.2.2.4 Roman 3 so and so
Ah.
is uncertain. And because it is uncertain, the said clause is hit by section 29. And the judgment in the case of reliance also categorically observes that if the term is uncertain, thereby giving and becoming ambiguous,
Subjective.
Subjective or ambiguous, then in such circumstances, it doesn't give a level playing field to the parties.
Yes.
And there may be a case of arbitrariness which may be resorted to by the respondents. One. Second argument is on the question of even if you are held to be technically not competent in terms with 2.2.4, they are to further consider, else it would be used as a blacklisting, taking into account the judgment of Atlanta. Third, this court passed an order when you filed the writ petition to consider your case. When they considered they should have considered and kept it in the in the seal cover, whatever may be, but without the leave of the court, they should not have proceeded with.
That shows, my lord, that malice in law.
And which therefore shows that there is a malice in law. And in fact, the incorporation of the ground of rejection of 2.2.2.2 also shows that they wanted to overreach the order passed by this court.
These are my answers. I'm deeply obliged.
Which one you are arguing?
5059.
Argue on one. What is that page 91? You are asking me to take one matter and another matter.
The lordship's kind permission. that is-
Yes, yes.
And if we lordship taking the
Okay. I take up the other. Yes,
page 99,
yes.
part of lordship 2.2.2.4. T2 lordship. In respect of 2.2.2 lordship, sir, only the mind lordship, that part I know. 2.2.2 lordship, the financial, that part I will not do.
Are you here first?
That part.
You have got, I have encapsulated 3 points
Yes.
where he has argued. You reply on that.
Was, so lordship, first part is also in respect of 2.2.2.4, human T2 lordship. There should not be history of collapse of superstructure of any span of a piece. However, that from metro line.
First tell me whether that clarification which is being made on 18.5 is pursuant to this tender? Pursuant to this tender, because earlier you had a clause
5 years period.
5 years.
5 years period, there was a proposal from some of the regarded, it should be.
So when did this happen? Before issuing this. Then why the query has been put at 2/3 years?
2 years. Proposal it should be 2 years. Some of the says that it should be deleted and some says that it should be 3 years.
So there is therefore the query was either deleted
It should be deleted.
or if this clause is there, then make it 2/3 years.
Yes.
What is the meaning? Because so after this 18.5, this fresh tender was issued.
That part,
Huh?
that part.
This is a corrigendum.
That is a part of the tender document.
This is a tender only. Is it a corrigendum? No, it's a fresh tender. Instruction to bidder is a fresh tender upon page 91. So therefore, when was this tender issued? (19/5, 2025). Okay, so this must have been done after 18/5. So therefore, it is there. So you say in the clarification you have given that this aspect would mean only design failure or if there is a of the permanent structure. Isn't it? It says collapse of the superstructure oblique substructure pertain to design failure or quality related failure of permanent structure would be considered for this clause only. So therefore, this happened pursuant to this 18/5. Okay. Now tell me why this aspect was not brought in the tender? Because you see, after this tender also there is a scope of clarification in view of clause 3.1.4.
When there is a conflict clause or other one, there is a contradiction and that part will count.
Okay. No, therefore, why this clause 3.2.4.4, 2.2.4 was, which had 5 years, was sent for clarification?
The lordship, the previous meeting, that part was discussed, lordship. After that, lordship, the authority has lordship held that should be 3 years period. After
So
discuss-
the authority have decided.
The authority has decided.
When did the authority decide?
Before this,
So they have decided it. So they wanted to do it prior to this.
Lord,
So thereafter, it went to again for clarification. This clarification which is done on 18/5/2025, is it on the basis of a clarification sought for in terms with clause 3.14 which was there in the pre-existing one? This clarification, how did it happen?
for the lordship, the previous meeting was held, the condition is there, the lordship.
Pre-bid meeting has to be on the basis of some tender.
Lordship.
It cannot be on in vacant. No, so therefore, prior to this tender which was issued on 19/5/2025, what tender did you issue?
5 years more there also.
So you issued this tender when? The earlier one? The first tender? No, 19/5 is after this all this clarification being done.
2025, revised on 23/7.
No, this page 148 happened when? My question is this. When did page 148 happen?
148 is lordship after 19/5 lordship.
So this is after 19/5. So that is what I am asking you.
After 19.
So who was saying that it was 18/5?
Oh.
Didn't he say 18/5?
Tender was, my lord, issued on 19/5. Then pre-bid meeting was called. Pre-bid results were declared on 23/7 and the revised RFP was then issued on 23/7.
No, 19/5 is this.
19/5 is the original 5-year clause.
1 to 1.
19/5 has
5 years term.
no, but you see, kindly come to this at page 99 of WBC number 5051. Kindly come to page 99. Is it a part of the 19/5?
No, my lords. Page 99 is 3 years. This is the RFP as revised on 23/7.
So
This
why
is the
you are
tender.
enclosing this along with this?
No, my lords. My lords may see my index of 5051. That I believe my lords will make things clear. My lords, annexure 4 is true copy of the RFP dated, the date of RFP has not changed, but I have mentioned there as revised on 23/7/2025. That's my annexure 4, my lords.
So this
Is what is prevalent today. Annexure 5 is the original RFP dated 19/5.
where is the corrigendum issued?
The corrigendum is annexure 6, my lords. True copy of pre-bid clarifications issued by.
No, that is not a corrigendum.
That is the clarification, but.
This is a clarification.
There was a
My
clarification.
question therefore is, you have mentioned a date of 23/7/2025. Where is that document?
My lords, that is the revised RFP.
Where is that?
That is going to the
Where?
2/23/7.
Page 77, Lords.
No, 77 is the revise.
Revise, sir.
Okay. So page 132 is what?
132 is the original RFP.
So 132 is the original. Where is the first page of that?
First page is Lordship, page 121, Lordship. Page 121, Lordship.
Okay, so it is. Now, why in this one, annexure 4, page 77, is there any mention as regards a revised RFP? No.
No, my lords, but this was issued on this was released on the same day as the pre-bid clarifications were issued. So pre-bid clarifications were issued on 23/7, and this revised RFP was also issued on the same date on the portal. That's why we have not changed the date. We have mentioned it as the RFP dated 9/5/2025.
So this was issued
and
on
revised
23/7.
23/7.
Okay, so this decision was taken pursuant to the first RFP
Yes. There was.
of 19/5. It was held on 23/7, these clarifications.
Yes, this clarification was issued. So basically 19/5, they would have issued the original RFP. They would have called for some queries from the bidders, and they responded to queries on 23/7, wherein that clarification from 5 to 3 years was done.
So there it was done. Then tell me why, therefore, it is the mention of 2/3 years in that clarification at page 148. You see, deletion of the above clause or modification as there would be a history of collapse of superstructure of any span of so-and-so via so-and-so for line construction service in the last 2/3 years, ending the last thing. So they say 2/3 years. So you went for 3 years. But there is no clarification for that 2/3 years in this thing. You only mentioned the clarification is to be incorporated in the RFP. The collapse of the superstructure so and so. Now, what do you mean by this line? The clarification has to be incorporated in the revised RFP.
RFP is a revised, that part is 77.
Now, understood. So why this line is not there? The collapse of the superstructure pertains to design failure of so and so and would be considered in this clause only. Why that line is not there? Where?
99.
Huh? Where?
Superstructure, substructure, release from resources by the network. 102, find this key item. 102. 102.
Yes. Where?
102.
Page 102. Huh?
6625. And this is next file. That's a third bit in the 6625. Please see page 102.
Yes.
T2, last bottom. This will be good instead of left of 20 to. So in the last 3 years ending, last year of month previous to service. 3 years. Earlier.
No. I understand. Mr. Das, this is not the question which I am asking. My question is, when it is mentioned out that this clarification shall be mentioned in the RFP, Why this clarification that it is only they will only consider this aspect is not mentioned? My question is that.
Right, I've understood. What you say, the queries and the remarks. And the remark, clarification has been important, where is that? What you say?
That is what is my question. That is not there.
But sir, will be that is circular to all the bidders, it has come from them. They are, what is also aware of. All the bidders are aware of. So what's it right? Logic is asking a query to that.
Yes.
There was this very specific clause. There is no doubt. There is no ambiguity logic. It's very specific. In particular clause.
So what is your submission on this point?
That point is
His first point is on the question of vagueness, on the case of ambiguous.
very specific. We go by the line of the language of the tender condition.
Read with the clarification. And he knew about the clarification as he has made it a part of the. No, he knew about that clause as he has mentioned in his undertaking.
Complete at all.
Okay. What about the second one?
Second one, in respect of second one, Rosi has already pointed. Otherwise, financial year part loss, we go by the company's act loss.
No, let us go, not that. The second point, the first point is ambiguity. Second point is saying it is in violation of, it amounts to blacklisting.
Blacklisting part. Rosi, then Rosi, the authority of the inviting authority, we cannot put a single terms and conditions. When financial part also, we cannot put loss. If we go by that proposition, Rosi, then Rosi, say Rosi, the financial 5,000 crores is required for that particular project, Rosi. Then we cannot impose the condition, Rosi. 1 rupee person also can participate in the loss. If Rosi, we impose a condition that 5,000 crores is required for a particular tender, then Rosi, below 5,000, everyone will be divided, Rosi. Everyone should be divided in the blacklisted, Rosi. That part cannot be. That part cannot be. We have the tender inviting authority.
So you don't want to abide by the judgment of Atlanta?
Debarment when it.
No. Atlanta is not debarment. This one is debarment. No. A blue image is debarment. But Atlanta is also says that you are debarred. Anybody who has been blacklisted out there shall not be allowed to participate.
Here we have not blacklisted those. The particular tender condition is applicable to all laws. It is not the case that particular tender condition was imputed by us or by us for the favorable decision to another tender laws. By this tender condition, we have losses reward more than losses 5 to 6 reputed companies of the losses, private limited companies participating in the tender loss. MNP was reward loss. That was given from beach collapse or reward. Calcutta beach collapse, that particular company was also reward loss. They are the famous losses with construction.
But your government of Assam has been giving everything.
In 2019 losses. That particular beach, now we should be open on 12 losses.
14.
14 losses. It will be on 1919 loss. 2019, that was tender issue losses. Here we have issued that particular tender was evaluated in 2025. That Patna collapse was losses the previous year loss. And they have given an undertaking before the Honorable Patna High Court. There is no dispute that process. This span of the beach was collapsed loss. Span is a permanent structure loss. Between the two pillars loss. It cannot be treated as a loss, not a permanent structure loss.
The bridge in Patna was not actually functioning.
No.
It was under construction. It was an under construction.
Construction time loss, that particular more than 16 span was already completed. The completed span loss, he was collapsed. And they have given undertaking before the Honorable Patna High Court that They have repaired it, they have made it from their own pocket loss. Why their own pocket loss? This is the judgment, my lord, they kindly pay the Patna High Court judgment loss. Page 200 loss. The orders loss, Honorable Patna High Court orders loss.
Yes.
All the above repetition arises from an incident which has evoked surprise and shock of the response of a bridge under construction collapsing. We had directed the learned advocate general to file a counter affidavit which is placed on record. And in the course of proceeding, we have also implicated the managing director of the contractor so and who had taken up the work of the construction of the bridge. It was also submitted before us that the discussion were going on between the agency and the state in so far as the construction to be continued only after the collapse fund being reconstructed without any additional cost to the government loss. Now the agency, though its managing director is undertaken to construct the collapse fund by itself without any additional cost of the government loss. This is the undertaking given before the Honorable Patna High Court loss. On the basis of that, Honorable Patna High Court has allowed them to reconstruct it on the agreement in between the state laws. And in that particular case, Honorable Patna High Court never decided the merits of the case. They only go for the agreement part, for the understanding part between the government and the lawsuit. And even even 2000 page 202, my lord, kindly page.
What do you mean by the term?
202, my lord, kindly.
What do you mean by the term superstructure oblique substructure?
Superstructure, the lordship, that piece lordship, the pillar and the span lordship, pillar and the that two part lordship.
Huh?
Pillar, then my chief engineer is also here, he can explain that lordship.
Please explain, please.
Yes, I also.
Good. Yes, what is the superstructure?
We divide superstructure and surface. The superstructure, those are lie on above the span, above the bearings.
Above the?
Bearings. Substructure is those provided.
For me, I am a layman. Let us take the example of the bridge which is going to be completed on 14. I could see some pillars. In the building, in the bridge. These pillars are the superstructure or the substructure?
We'll call it substructure.
Substructure. And the span which goes above it,
That's
that's the superstructure. So the substructure and the superstructure. Take it. Now, any construction, if it is half made, just for example, in Delhi, we could hear the metro. There was a collapse. So metro, it was under ongoing construction. Maybe some may not be for design or anything, but it may have collapsed for accidental reasons or for force majeure. So as per your clarification, they did not place that it is a case of force majeure. It will only come when it is a case of design failure or what is the other one? Quality failure. Now, is it your case that if they have stated that it was not a case of design failure or quality failure, you would have asked them? But having not done so, they have only said that it is ambiguous. So you rejected it.
Design part, my lord, 202 page. What is the observation before the Patna High Court? 202.
No, let us not go too much into that.
Even design part also, see, Honorable Patna High Court says that the design will now be random and remodel lordship. That part also they have fault lordship. If we go by the design part also, lordship. Yes. If we go by the design part also, that part is there also. In the before the Patna High Court, they admitted fact.
Okay. Anything more?
If lordship permit, I can invite to his husband.
Please.
Then this is review part. Thus, time consuming, nothing else. His husband lordship.
You rely to judgment keeping in mind that this court has some basic knowledge. Yes, yes, what is your judgment?
First, and yeah, it's before the Jagdish Mandal was. It's before the Jagdish Mandal, I guess. Paragraph 7 also, I'm in line.
Cochin,
First,
what do you say?
paragraph 7 also. The Lord electing to the award of a contract by the state, its corporation and.
So here it says the question of natural justice does not apply, isn't it?
Does not apply, well, also, we made out a legal point also that will not do.
Where?
That is in page.
The award of the contract, which it is a private party or a human, is essentially a commercial transaction in arriving. The state can choose its own method to arrive at a decision here. The tender conditions permit such a relaxation, it may not be influenced for the state. Man to be paid or concern even there is some defect is found in the decision the footnotes. Then
And also Jagdish Mandal. We have 22 lawsuits.
where does it say?
We have 22.
Yes, what is that? एक इधर लिखी लो उसमें गूगल एक बार
Then lawsuit. 1022 100 plus lawsuit. That paragraph here I'm in line 42 lawsuit. And
is this the judgment of oh okay GP and which one next?
Balaji Ganta lawsuit.
Huh?
Balaji Ganta.
No, how many more judgments?
Computation part lawsuit I have given. Happy street lawsuit.
No. You see, you apply the judgments which are relevant. Just for example, what is his submission? His submission is, you see, the clause is vague. The clause is vague. The clause is ambiguous. The clause is accordingly when there is an uncertainty into the clause. So therefore, it is in violation of, because terms of the contract of the notice inviting tender also amounts to formation of a contract. So therefore, it will violate Article 20, Section 29. Section 29 of the contract that says agreement which is uncertain is void. Reliance judgment says that if there is vagueness, it leads to arbitrariness, taking into account there is no level playing field. Now you are to therefore show me, unless don't show me all these too many judgments, to show me in a case which is whether from reading of 2.2.4 read with the clarification, there was no ambiguity. There is no uncertainty. And the authority, if he looks into it and says that, look here, I have understood in this manner. So the court should defer its decision. Where is the judgment? Don't keep on showing me so many judgments. Which one? Show me only one judgment. Again, you are showing me, you have given so many judgments. Don't show me under the ear. Para? Which one is it? 36. This court ought to refer to the discretion of the tendering authority by which reason of the author the document in the best place to interpret the term. The court ought not to sit as court of appeal, but review the decision-making process and examine arbitrariness or malafide. Yes, where?
Then paragraph 35 also lawsuit. And Tata is also there. I am not relying because Tata is also declared. Tata is also discussed here also. Regarding technical issues for paragraph 30, I will take care of it.
This is the Tata one.
Tata,
Tata judgment refers to Jagdish.
it is 2024 Tata, I am mentioning.
I know that. That is the best one, best judgment, the best, this best buses
Yes.
of Tata.
Lots.
That is, I think, is a judgment by Justice Pardiwala.
Lots.
Oh, yes. Then,
Lots.
so this is as per FCONS. But the question now is, the Supreme Court says that your discretion or you being the author, you are the best person. How do you know that you have looked into in that manner?
That condition itself says no. That condition itself.
Tender condition says,
Is there
no, tender condition says that this is so and so.
lots?
If it is a vague or not, or whether it is ambiguous or not, thereby not providing the level playing field, are you not to explain somewhere that this is what we meant?
That part also we are regarding technical part, then the very well planned will also. Whatever the 6 bidders is participated also. 6 bidders is participated, not there also 2 bidders he or he is participated. 6 bidders is participated also. Not you are this. Not say that also you guys speak there also in the microwave somewhere else.
Have you mentioned in your affidavit, your file affidavit, that it is not vague or ambiguous?
Regarding that part also probably we have not mentioned.
That is the most only, that is why Mr. Ken Chaudhary has argued that point only.
That part.
Eh?
Otherwise, that's the.
Then therefore the question would be, if you have not explained, because your claim is that you have rejected him on 2.2.2.4 as well as 2.2.24 Roman 3. You have only said that. But the question is, if you have not said anything, how do I defer it? That I should defer to the decision of the authority. Then the jurisdiction comes to this court. Don't you think so?
Indeed, my lord.
Paragraph 13, I have stated lossy, we have stated lossy.
One line is there. Only one line is required.
We have stated that lossy, the qualification criteria is applicable for all the.
Of which affidavit? 5051.
5051.
Para?
Paragraph 13 lossy.
The answer independent begs to say the qualification criteria is applicable to all bidders. I'm not saying what does the qualifying condition mention?
We have stated. Regarding the variation part.
Awarded conduct or whereas the present work conduct is for the important breeze of so and so. Where did you say? How did you deal with 2.2.4?
2.2.4 lossy, 2.
That all doubts and queries were discussed and clarified in the pre-bid meeting for and hence there is no question of no responding from the Iman. So and so 5-year history is reduced to 3 years based on various queries. So and so the same are duly already clarified in the revised RFP and reaffirmed the statements made of the 8th of the affidavit. This is another one. What is this? Kindly come to page 29. Made in paragraph number 8. What did you say in 8? Also mentioned in a structure of so and so of the lining work. Wearing coat, pavement, and also that in a simple member is taken as a permanent structure, excluding so and also mentioned in the revised view. That is also so and so line under work during construction. So you are there, paragraph 8. Refer to only paragraph 8. This is your understanding. Including time for clarification in the manner and for the date of swearing. You also make a submission as regards 3.14 also, no? That is the fourth submission.
Yes.
Okay.
Yes, sir.
Okay, then anything more? No. I'm giving you both so much of opportunity, otherwise it's a matter of 25 minutes. Let me come back and hear Mr. Diganta Das, the senior counsel. I write at 4. I have a bench at 4. Huh? 3:45 I'll rise. Okay. It's only 5 minutes. Let me come back in 5 minutes.
I remember one thing here right away. My lord, this was in port number 2. I not name a particular director. He said you should know when to speak and when not to speak.
Oh.
So, my lord, my argument will be very limited to the extent I am a beneficiary. One thing which I like to point out before this court. One, he knew about the terms and conditions of this clause. For 1905, 2025, then when the tender was floated. Please see the representation which he have filed. When this clause was there for a period of 5 years, please see representation. Kindly see representation. What is his representation?
Where is it?
Yes, in the first repetition. In first repetition at phase 211.
Yes.
See 212, kindly turn to page 212. C5. Notwithstanding the vast experience in design and construction of bridges, open to consider fail safe design and construction, we have encountered unforeseeable and accidental collapse of part of two spanning chain effect so and so with footpath across so and so, including navigation so and so, appropriate so and so as of it has not been detected cause of collapse. Invariably, every contract provides for terms and conditions for such unforeseeable accident, insurance, and so and so. Now, please look into the next minor at page 213. See page 2137. Down below, we consider cross 2.2.24 so and so, rather than require review and revision in the interest of the benefits of better computation. Benefit of learning from accidents, make use of the insight gain. Such like clauses are conflict of reasonableness. We humbly pray that a competent authority may please to delete the following clause in the larger public interest and public access. Such like clause never specified by the government of India earlier so and so. We quote most recent invitations of students. So, my lord, they were aware. Even in the representation, they said for the better interest of the public, they should remove this clause. Now, this is, my lord, the representation which they have filed is of 31/5/2025.
Before the next.
Correct. Next, my lord, the three-week meeting, after that queries, remarks your lordship has seen, then clarification has been made to the extent. Now, thereafter, they did not find any representation to the authority also. That this look here, this is what we want. Where is that? Let my learned friend show where is that. After that clarification also, there was some representation was.
For the matter, after the RFP of 23/7/2025.
Yes.
Is there any representation submitted by them
No,
seeking
they
clarification?
did not. I'll say relevant date. Read was filed on 29/8/2025. Now, after submission of bid 27/8/2025, now they come to the court and they said this is what has been done. And my lord will kindly see. I will say one step further that it is a perjury. Because why? If you see their undertaking, please see the undertaking which they have given. Undertaking which is given, there is a caveat in the undertaking. Kindly see the next repetition where there is an undertaking which is given. And
No, it is here also. Oh, no, not here. No?
My lord, 124.
It is not here. In the first one?
It has been filed as an additional affidavit.
In the first one. Show me that.
I will see at page 124.
Yes.
124, kindly see the last paragraph. Subject to the following is disclosed in respect of answer, unforeseeable collapse, a part of spent so and so on the instruction employer, therein as per order dated so and so of the Honorable High Court, so and so period, re-execution collapse part of spent work by bidder is able under force measure clause 21. Where is that? Why not we read the entire order of the Patna High Court? Not a single whisper has been made that is under force measure clause. No, nothing. It is a design. Kindly see the order. See the order itself, my lord. It is amount in perjury. In a judicial proceeding, where is that, my lord? Kindly see the order. Page 188, kindly see that. 198.
Now, Mr. Gogoi has
Yes,
referred.
not a single whisper, my lord. It is, they have given undertaking, we'll do it of our own. They said either you do it, you have to spend. They have done it of their own. There was a fault of the design. They have done it. And today, they have given an undertaking, putting a caveat that this is what. And one of the case is, why you participated, knowing fully the clause and knowing very well this is what. And there is a caveat to his undertaking.
So, in the clarifications which have been given at page 148 of the old writ petition, there are three aspects. One is deletion.
Yes.
You see the query, deletion, then so and so for 2/3 years. So the deletion was his request on 31/5/2020.
Right.
And the other must be given by L&T, making it 2/3 years.
L&T, what? This is what? My lord, years. 2 years, not 3
And
years.
who gave 3 years?
Deletion also. We also saw the deletion.
Some other
Deletion
bidder.
for 2 years, not 3 years. Deletion also 2 years also. It is up to the prerogative of the employer, my lord. And all 6 bidder participated. Yes. My lord, our is the bidder request to delete the clause in its entirety or suggest the modify the clause as below. Which is 2 years. And also you can look into record. This is what we say.
Chalo.
We are
Now,
regard-
now,
my lord,
now argue the next thing. If the petitioner is not entitled to the relief as has been sought for in the first writ petition,
yes.
what happens to the second?
Second is that present.
And the second one,
Yes, second one.
what happens?
He's on my law, everything falls down. If he's not, he
If
doesn't get.
the challenge to the clause
Yes.
which he has made in the first writ petition fails, and as he had submitted an undertaking which is not in conformity as per them, has to be looked into in the second. I can't look into in the first. I have to look it in the second.
Because why? Second is when the LOI is issued. LOI issued, my lord. Then they came and made us a party in the second petition.
Understood.
issued. Now
No,
there was.
prior to that
No.
also, no, Mr. Das, prior to that also, there was another writ petition filed,
Yes.
which was withdrawn
Correct.
with liberty to
Right.
file in
That
view
was
of the
withdrawn.
LOI issued. So therefore, they initially came up with the rejection done under 2.2.2 and 2.2.4. Now, 2.2.2 I'm not there look into, but 2.2.4. So 2.2.4, if clause 2.2.4 is okay, because here he has challenged in 5150.
Yes, correct.
If I say it to be okay, then what is the scope in the second one?
Second one automatically goes on. If it is.
Because there is no undertaking with a format of undertaking given. So how do I deal with that aspect in the second one?
First petition. You will also decide the first petition.
No, I say that if okay, the clause is okay.
No. If that clause is okay, then his basic, what is the basic challenge of the situation?
2.2.4.
Challenge is about that clause. Now your lordship holds that that clause itself, there is nothing wrong with the clause. So what then automatically the second repetition, what is about the second repetition? The second repetition which has put to challenge is my LOI. Now he also that he says that particular clause, which is only, this is what he said, is only for favoring the respondent. That's what he says.
No, not on that. He has given an undertaking without prejudice.
Yes.
And this undertaking was taken into consideration by them, resulting in his disqualification under 2.2.4. So the first repetition does not take care of or does not relate to the undertaking. Only says that this is the terms. Now I hold that okay, the term is okay. So therefore, in my second repetition, I have to look into it. That in absence of the format, as to whether the clause 2.2.4, along with the clarification, have been fulfilled or not.
Then what is your lordship has to look into it? Your lordship has looked into what is the undertaking? That whether it's a qualified or it is not a qualified. If it is not a qualified, and if there is a category, just end of the matter. No, see, that's the controversy.
Again, they can be qualified also because clause 2.2.4 does not say about qualification.
But my lord, 3.1.6 sees a test of responsiveness. Page 117. First repetition. Third, my lord.
Yes, where?
3.16 and page 10117.
114. As a first step towards evaluation, the authority shall determine whether the AI is responsive to the requirement of the AI. Technical bid set consists of so and so, so and so, so and so. Shall accompanied by bid security. Power of attorney is accompanied by power. Shall all information complete in assess it does not contain any condition of qualification.
Yes. Now see now, you please read page 95. Can you see 95?
So therefore, you say the AI is wrong in view of clause 3.1.6.1 G
Right.
because it is qualified.
Correct. And red way, see page 95, 2.1.7. 2.1.7
Of
of same RF. 95. Ninety-five, 2.1.7.
yes. Any condition of qualification or any other stipulation contained in the bid shall render the bid liable to rejection as a non-response.
Now please see the undertaking which your lordship has gone through. I don't want to
Now tell me,
Yes.
if we look into the undertaking,
Yes, I'm coming.
is it conditional?
Please see 125.
Now, is it conditional?
Kindly say it's a conditional. 125.
What is the
I
condition?
just read it. 4 lines. Accordingly, undertaking is given. This undertaking is without prejudice to all the rights of the leader, including.
That is not a condition.
My lord will give my submission to this is as a conditional one. And there is a caveat.
Because
If
if
you
we
read-
say that, it will not only affect the rights under Article 226 of the Constitution, but also would affect the rights under Section 27 of the Indian Contract Act.
My lord will kindly see. This undertaking at page 124. My lord, it is not a qualified undertaking. This is my submission.
There's no
It
necessity.
is unqualified. It is not, it's unqualified. Can you see mine? By reading each of the paragraph, he wants to explain, see our undertaking.
Mr.
It has to be
Gogoi,
clear-cut undertaking.
you must be having your minutes of the meeting. Only minutes of the meeting, give it to me. Let us not go into qualified conditional because it will have you will have a problem. Three more minutes. Anything more?
Accounts, relied on accounts, Monte Carlo, these two judgments. I don't know trouble more,
And Galaxy.
the Galaxy. These are three judgments which have occurred. And my lord, 6 bidders participated in this case. 4 found non-responsive, LNT and Afcons qualified. My lord, I have supplied the copy of the judgments.
Where is that technical committee meeting? Let us see where they have looked into. You have given such a big file, I may have to stand up. No, it's okay, that is not there, but it is so big, I have to stand up and see. You give me a photocopy of this. Okay? Give me a photocopy of this. We'll see, because this is the technical evaluation. I don't need the others, only give me that.
One judgment,
What?
of this,
Huh.
we see 44, paragraph 44.
What does it say?
I'll just read my 44, I'll just hand over. See paragraph 44. Under the certain.
Yes.
Under the circumstances, the High Court is committed a grave error in holding the clause 28.1 and 42.5 of patently illegal, more particularly in the absence of any challenge to the same. And also on the ground that one, the original petitioner participant having knowledge of the aforesaid clause in ITP, thereafter it was not open for the original petitioner to challenge the same. The original petitioner was knowing right from the very beginning with respect to the confidentiality clause containing clause 28, and that ground on which we the unsuccessful bidders are not selected shall be communicated after a final decision to award the contract and so and so. If the original petitioner agreed, either it would not have participated and or also have challenged such clauses without participating in the tender. Under such circumstances, impute judgment order so and so illegal cannot sustain the same.
A baki judgment book. Okay, hearing complete. Judgment reserved.
This question another second question. Here is pass on also. And mass common judgment common reason. So we have itself.
Okay. Judgment is, I would have delivered the judgment in the court, taking into account. Anyways, the facts are not so much. Hey, you do, all of you will do one thing. You give me, you have referred to some judgments. He has referred, he has referred.
Yeah.
Give me ask him who have referred and then give it to me. We'll get the judgment in this week. Yeah.
Deeply obliged.
Mr. Ganguly, where is he? We seen there's a production list somewhere. let us take up this matter on some other day. Itu eta fix koi dibo. Well, let us have it, it is a small issue out there. This matter again on the order আছে না? This matter was taking into account the order passed by the learned coordinate bench of this court dated 10/2/2026, as well as the order passed by this court on 27/1/2026. List this matter on 16th of February 2026 at 2 p.m. for final disposal. Anything else? It has to be extended, any interim order? No.
Be clear.
Item number 1.
Mr. Ella, can you explain what is this aspect which is given in paragraph number 6 and 7? More particularly 7?
This one not actually it's a limit on the that the finance literally this amount is made for the issuance of financial sanction without forbearance of the finance department. To that extent, the amount is available. The amount is available. There is no limit as far as the budgeted amount is concerned. So only the financial sanctions for the limit is to that extent.
So therefore, we are to understand. So if there is a budget allocated in a particular head for the cleanliness or housing expenditure, what do you call it? Housekeeping expenditure. The amount can be spent irrespective of there being a financial sanction or not. So then if the budget is allocated and there is a requirement of a financial sanction,
So ultimately, it is a precondition for issuance disbursement of the amount.
so therefore, irrespective of the money being there,
Yes.
which is the budget of 1.21 crores, they cannot use it unless there is a financial sanction granted.
To the previous bill. To the previous bill, or if there is any bill pending.
If not, just for example, the court says that we need 1.21 crores. Now this money is there in your budget, as they say so. Now, this amount cannot be spent by them or used unless there is a financial sanction.
As of
They
now,
can use only for an amount of rupees 2 lakhs per month.
Yes.
Without the financial sanction.
without the financial.
But without the, but because of the capping,
Yes.
they cannot use the 1.21. Okay. Now,
So-
are we to understand
Yes.
that the entire district judiciary as well as the High Court on the aspect of cleanliness and maintenance of toilets can only spend 2 lakhs?
No, man, that is not the case. There is no capping, there is no limit so far as the spending of the amount is concerned.
But provided the financial sanction is not granted, it cannot be done. Now, how often do you give the finance? How much time does it take for when you apply for a financial sanction?
That is why, Madam,
Here, the finance department has produced a letter before us on the last occasion, which I have referred to. They say that they have 1.21 crores and they can very well spend it. Although there is no, this doesn't comes under the supplementary budget. So supplementary budget which is being sought for is separate from this 1.21 crores. Now they need the money. So, though the finance department says they can spend it, but without the financial sanction being granted, taking into account that it is above 2 lakhs, it cannot happen. Now, does the finance department or all these departments?
Existing finance department, DAPR rules, existing DAPR rules, that is the provision. I will, it seems that there is a difficulty in this way, as Varad has pointed out. Now, we have had a meeting on the 9th of February, the finance department, and we have requested them to strictly modify the rule.
Modification of the rules will happen.
Yes, sir.
But why the financial sanction is not being granted? They know, they on one hand, the finance department says that they use it.
No,
But in that letter, they say 1.21 crores, you use it. But how will you use it unless they don't give the financial sanction? So therefore, forget about the GFR rules, that will take its time. But are you therefore saying that there should not be any cleanliness and maintenance of the toilets on the ground that the financial sanction is awaiting, although money is there? So the finance department has to pull up their socks and grant the sanction for this 1.21 crore. Or should we construe that the letter which was placed before this court to be the financial sanction? Because they say, use it. Mr. B. Gogoi?
Proposal, supplementary proposal of 1.84.
That is different. That has not been considered by the finance department. Yes.
Please, in inverted full budget provision of rupees 1.01 lakh under the head account, under the above head of account for current financial year 2026, have yielded department and incurred expenses.
Mr. Gogoi, this is aspect has been duly mentioned in our order. We know the reason.
That part may be.
So you therefore say that a supplementary demand has been made, but still they have 1.21 crores. We are not on that. We are concerned with when you are saying that 1.21 crores can be spent by them. Would you construe to be the financial sanction?
That part, the proposal.
They have mooted a proposal of 1.243 crores. You may reject it. You may not consider it. But when you are saying that 1.21 crores is already there, they can spend it from there, and they have only spent 1 lakh, why are you not granting the financial sanction?
After this observation, proposal has probably not been sent.
No, Mr. Gogoi, if I am not wrong, please forget about for the time being that one additional. Forget about the supplementary. You say that there is already 1 point so on and so forth money is there. You spend it. But there is a cap that you cannot spend more than 2 lakhs in the month. Now, how will you send it to spend this entire amount? Tell us that.
Well, for this model.
Huh.
Out of this matter.
Huh.
Well, what let the proposal go, my lord, what might not the commissioner today morning also have talked to the commissioner. finance department. He said that there is no capping as such. Supposingly, my lord, tax per department, say in a district, he has a limit of 2 lakhs. Now, if he wants say 5 lakhs, in that case, he will move the proposal to the higher authority for 5 lakhs, and that will be provided. It's not that given to it will not be provided. A capping though is there, or whatever we say limit is there, but ahead of that, if it is anything is required, the proposal will have to be submitted, it will be provided. We have never said no. That is what the commissioner said. While means my lord, that now the capping is there for the registry of the honorable court. Now a proposal for anything beyond that, my lord, will have to be submitted to the judicial. Judicial will move the final, then whatever amount is required, that will be paid.
Within that budget provision already made.
There's no doubt about
So
it.
according to you, you need not exceed 1.21, what is already,
Yes,
provision is
but
already,
it is
already made. But for that, there may be capping, give us a proposal, we will clear tomorrow.
So should we take it that you are going to clear it with the moment the judicial report?
Yes.
Already the capping part, my lord. Good news is that, my lord, already proposal has been moved. I will not say the amount, it's a huge amount, my lord. It is lying before the highest authority. And probably, my lord, that will sort it out.
Let it be. That is another aspect. No, that is another aspect.
Yes.
As to whether the GFR rules are required to be amended or not. The problem is, there is no, you see, you know it very well that they require 1.23 crores for which a supplementary demand has been made. They move the finance department for the purpose of the 1.23 crores. You say that 1 to 121 is there and again asking for another proposal for this 1.21. Are you not therefore just making it delayed the thing? You see, certain things.
The money has not been placed, actually, not sure, that is the difficulty. I mean, money has not been placed at the disposal of the administrative authority. And that is why, to that extent, my lord, that is being made now, my lord. We think that will be sorted out, my lord. The money will be placed with the authority, my lord. In that case, in that event, my lord.
Don't say tomorrow that money will be placed and it is not been placed before you need, we need a fresh proposal. Where is the proposal of using earlier budgetary provision? Where is the proposal of use of earlier budgetary provision beyond the cap? Where is the proposal?
That has already been moved, the government of.
Where is that?
It is pending for the highest authority, my lord. We are in touch with the finance department. We held discussion on this aspect, my lord. This aspect is being considered by the highest authority and it will be sorted out, my lord. As of now, the system is like this, my lord. That is the difficulty. And the financial sanction, already one financial sanction has been directly sent from the High Court to the finance department. There is again a difficulty with the current rules. It was not routed through the judicial department. So now it has to be again returned back to the High Court. Again, the High Court has to send us to the judicial department and the judicial has to.
So after the letter which have been written by them, which I have made a reference in, we have made a reference in the order, it is 5/2/2026. The High Court has to again move the proposal for 1.21.
No.
It is you.
No. Proposal is.
Who has to move the proposal for the financial sanction for getting the amount of 1.21?
So 1.21 crore, my lord, the budgetary provision, my lord. Now, every bill has to be sanctioned. Each and every individual bill has to be sanctioned from that amount. So the amount has not been placed in at the disposal of the judicial department. It is lying with the finance department. The amount 1.21 is still lying with the finance department. It is budgeted in allocated amount. Every financial sanction has to be against a particular bill. So the financial sanction of beyond 2 lakhs has to be sanctioned as per the present rules by the finance department. That is what we are proposing to change now. It has already been moved to the highest authority, my lord. I think it is sorted out very soon.
No, understood. But my question is, as regards they say that as regards 1.21 crores, it is the budget is already available with you. They say.
It is the budgeted amount. It is available with finance.
But why they say that you use this? How will you use that?
No,
Please tell us that.
No, that is not the case.
Huh?
It is not lying with us.
So they say
It
you
is
use.
basically the judicial department.
Hence, the department can incur required expenditure for cleanliness work from the balance fund available during the current financial year. This is what has been stated by them.
Yes, sir. But that amount is lying with them. Sanction. as of now-
Understood. For that, they are going to give the financial
Yes,
sanction.
Yes.
Now, therefore, those bills which are there, have you forwarded to the finance department thereafter? After this, 5-2,
Yes. Sir.
have you forwarded to them? Then look here, we require this 1.21 lakh crores.
No, there is only one bill of the Honorable High Court that was forwarded directly to the finance department from.
What is the amount of that bill?
11 lakhs.
No. Here we are considering much higher amount. There has been no payment in regards this 1.35 lakh crores. I am told by how much it is total.
Lord, yes, on the last page in para 12, your lordship recorded that 1.3135 crore. Milord,
That is only for the High Court.
only for the including the subordinate judiciary, it will come around approximately 3.5 crore for cleanliness, Milord.
And maintenance.
And maintenance, Milord, approximately.
So this is done on what basis? How do you have used this 3.5? How do you arrive at this 3.5 crores?
Milord, sir,
Do you want to say you have already you have ordered for this? Somebody has given you the service, and this is the bill you need to pay now to them.
Milord, the problem that
Or
I'll
it is
just
an
explain.
advanced kind of proposition.
What problem is facing, Milord? In the month of January, a bill of 11 lakhs, and that sanction of that has not been saying this getting to 2 lakhs. The addition has made a loud submission that yes, 1 point some crore has been there. It can be, but there is a contradictory submission between LR. So because LR is saying until and unless we cannot read escaping if correctly the submission of.
And the entire amount
So
is not
we are-
placed at the
we are back to square one.
Judicial department.
So to square one, Milord. Ultimate sufferer is that we are not able to utilize that amount because each time the bill sent for clients and it will remain there, kept pending, again, same thing, Milord.
So judicial department is only a post office.
It's this, Milord.
So
And the additional
the
admin,
money is not placed at department, at judicial department.
because it's said, it's
Therefore,
like the finance,
the letter, he is a post office, your proposal is to go to him, he will forward it to that.
financial
If
sanction.
it is 11 lakhs, they will say, no, it is beyond
Then we can
monthly
pay.
sanction, we cannot.
My friend, and that
That
Oh.
appears so, Mr. Bogoi. That appears so. And this doesn't appear to be proper. No, this cannot happen like this. Is it something like that if the state of Assam does not have the capabilities of having a high court?
This is wrong, my lord.
It seems so. No, obviously it seems so. I'm saying so because of the fact. No, I'm not saying about anything else. For the purpose of maintenance of toilets, which is given as per the direction of the Supreme Court, the High Court have been requesting for the money, and you have not been making the payment. You are putting on GFR, capping, whatnot. A bill of January is of 11 lakhs is pending. You are putting the buck on the administrative department saying that they have 1.21 crores. Now, administrative department says that we have a problem out there because money has not landed in our department. For that, we again need the financial sanction. Now, how?
Financial you telling me, they will not give the financial sanction for 121 crore. Financial sanction again is having a limit.
Madam, regarding the 11 lakh, the proposal can be, madam, punished to me, I will place the clear picture.
for last
These are, we are hearing this whole proposal No, it is a proposal. Of course, they will have to be proposal. So what is this? Please make a submission as if my lord, we have not granted anything to the my lord.
This is not an at all an adversarial litigation.
Then
My learned brother should not
make
take
the
it.
submission, my lord.
No, no, no.
Just
I am,
then let's make the submission. We are trying to, my lord, sort out the issue, my lord. This sort of submission, my lord, at least, my lord, I don't appreciate.
I don't require any appreciation from brother Milord, but the fact is that
In fact,
The
my lord,
fact-
they- what they
the-
say
the
my
fact
lord,
is
I
that
could gather this, my lord, if a
for
amount
last-
is there, say 121 crores is there. Now, for that, supposing 11 lakhs is required, my lord, which is beyond that 2 lakhs. What I could understand, I talked with the commissioner. He said that their proposal will have to come from the judicial department, through the judicial department, to the finance department. And then it should be sanctioned. Now, what is the status of that 11 lakhs, my lord, proposal? If a copy of that proposal is submitted to me, I can, my lord, go to the root and I can tell what is happening to that, my lord. Today, suddenly, my lord, every day, my lord, when the matter comes up, they speak about proposal. But nothing is there on record. At least I can have a specific instruction.
There is-
Why this submission was not made on the last petition? I would have taken a specific instruction that why it is 11 lakhs and not being made of them. But today suddenly it comes up. Tomorrow Lordship will say after 2 days, again new some text will say that another 2 lakhs is pending. Give me something so that I can have a specific instruction. Nobody is saying, my lord. In fact, one of the commissioner said that we are ready to give anything to the judiciary. Every time we used to give.
No.
At least give me something.
No,
so that
Mr.
I can
Gogoi,
have a specific
no,
instruction.
Mr. Gogoi, kindly appreciate. Forget about the 11 lakhs. I'm not on that 11 lakhs.
Not on 11 lakhs.
Our question is, there is a supplementary demand made which the finance is not considered on the ground. That administrative department still has 1.21 lakh crores, and this amount has not been spent, only 1 lakh has been spent. So they can incur the expenditure from there. Rightly said, there's no quarrel with that proposition. But the fact that for that, have you asked them to submit a proposal for quarter bills, which is required to be cleared? Just for example, they must have asked for a supplementary demand on the basis of certain proposals. I don't think the I don't think the High Court has asked for a supplementary demand of 1.23 crores on the basis of just asking them, give us the money. No, it has gone on the basis of some proposals. These proposals forms the part for which the Judicial Department requests the Finance Department kindly provide a supplementary demand. Now the Finance Department supplementary the budget say the Finance Department says, look here, why do you need the financial supplementary demand? Already you have that money, you spend it from there. So therefore, the proposals pertaining to 1.23 crores is already there with the Judicial Department.
Not actually.
Huh?
Amount is not placed. That is the thing.
I'm not on the amount. Again, you are trying to. So the proposals which have been submitted by the High Court to the Judicial Department for which you have asked for a supplementary demand is already there with you. There's no quarrel with that proposition. Otherwise, you would not have asked for a final supplementary demand. So the proposals are already there. So from there, they say, okay, you spent from 1.21 crores. Now the question is, when you came to learn, because this is a letter being written to you, which forms a part of our order on 5/2/2026, have you provided that these are the proposals to the Finance Department? Kindly provide the financial sanction. My question is this. Have you done that?
We have not forwarded any new proposal. Not
So then how will the Finance Department act?
we are able to issue the financial sanctions or not because of the fact that this 2 lakh cap is there on us.
Who will issue financial sanctions?
Who is going to provide?
We have to issue, Manoj, but we are in a, because the system, it is a systemic thing, Manoj. In Assam, there is a system from where we issue the financial sanctions. The money is not available. If this cap is not removed, this limit is not removed, then we are not in a solution.
So have you requested the Financial Department that, okay, these are the proposals which are there. You say that we have 1.21 crores. So therefore, kindly provide the financial sanction for this 1.21 crores. Have you asked them? Because then only when they are the person who is going to remove the cap. As Mr. Gogoi just said, that if it is not only 2 lakhs or maybe 10 lakhs or 15 lakhs, if a proposal is being submitted, we will allow it. Have you moved that for removing the cap so that you can use 1.21 lakh crores? My specific question is this.
Proposal we had sent to them.
Have you asked for removal? Because unless they don't remove it, I understand your problem.
And we have the help meeting, take another part and requested to remove the cap.
Forget about the cap. Forget about the cap. Give them a proposal that this is our things for forgetting the cap because they have said, where is the question of cap? Already money is there, you spend it. So give that proposal whether 100 crores or 200 crores.
In every sanction letter, it is mentioned the particular head of account. Also, we see in that manner, it is stated the budget provision of doing so, like under the above head of account for the current financial year 2025-26. So it will, in the proposal, it will be mentioned that under this head of account, there is a number. This amount is pending. Out of this, we require 11 lakhs. That will be the proposal. That will be sanctioned. Where is that proposal? That's why I'm saying, I can go to the root of the issue.
So, no, that is the issue. What I'm asking. You see, just putting two steps. No, Mr. Chakraborty. Let us put two steps forward, backward. The High Court provides the sanction, provides a proposal of 1.23 crores. Is it clear? For which you submit to the department
Finance.
saying, kindly go for a supplementary demand. The proposals submitted by the High Court are with you. They say, why do you need a supplementary demand? You have already 1.21 crores. After spending 1 lakh, you still have that. So under such circumstances, you spend it from there. I understand that you cannot spend more than 2 lakhs because of the capping. But you have to request the finance department to provide to remove the capping for these proposals
Under
so
this
that
head of account.
under head of account. Have you done that?
Is there done in some portal where the requests are submitted before the final.
When did you do that? When? No. That is for supplementary demand. They say that you don't require the demand because you already have the money. So the
Under
question
this
is for removing the cap. You cannot allow the financial sanction in view of the cap being put up 2 lakhs. In view of the ZFR. Understood. But the finance department has the power to remove the cap. Isn't it, Mr. Gogoi?
Beyond the cap,
Anything required, the finance department has the power. Have you moved that proposal? My question is that. Where after getting that letter, which was placed before this court, and that part became a part of the record.
There is no proposal as such, my lord, after that letter.
No, those proposals.
Those proposals which
Yes.
have already been submitted. Have you asked him that in view of that you have asked us that we now have this
Can spend
1.21 crores, we can't spend it because there is a cap of 2 lakhs. Have you asked them kindly remove the cap for this?
That is
This is the simple question we are asking all this while. Then only they can remove the cap, which Mr. B. Gogoi submits that they will provide the cap, remove the cap for that amount which are Quado's proposals.
Situation after this communication. They see you need not,
Yes.
there is change of situation.
Capping will require a alteration of the.
not capping, anything beyond 2 lakh, submit additional proposal, so the head of account where the money is lying. Sanction amount in the budget provision, say 121. And that amount will be given. It's not that.
That is that. Have you done that? No. Have you done that? My question.
to Mr. Chakraborty, to you. My last question is to you.
Have you done that? What Mr. Gogoi is saying?
After that, what's the lordship's order, we have not moved any.
How do you get you see that there is no quarrel that there is a cap. And the cap is not on the basis of any executive instruction, it is on the basis of 170 GFR. So there is no worry. So under such circumstances, maybe the High Court or any administrative department have to follow that mandate. That's the rule. There's no quarrel with that. But the problem is, And they categorically say that if you provide them, and if they have the budget on that, they will provide it. They say that you have the budget in this head of account. Provide it. They will provide they have the power to remove the cap and they allow you to go for the financial sanction. Isn't it, Mr. Gugoi?
Require a change of the, amendment of the rule, my lord.
Why?
Oh, it is not your concern. Whether they change the rule or not, what he has fallen from Mr. Gogoi is, see,
Meeting with,
please listen to us. What is our understanding? There is a budgetary provision under this head of account. This head of account, there may be money, but it cannot be spent more than this in a month. But there may be situation where we need to spend beyond that cap. So for that, you need a proposal, what I have understood, to give, let's see, this is the head of account, these monies are lying, these are our expenditure, please sanction this money. Then they will give a financial sanction and place the money before you. Then you will release it to it. Is it?
yes, but that is what the commissioner has said.
Yes, that is what I am saying.
We have requested, my lord,
Request verbal.
we had a meeting with the.
No, meeting verbal request or with this proposal, this is head of account. You need some formalities.
Meeting, physical meeting. Physical meeting with the finance.
Meeting will not do. We cannot give you sanction money on basis of minutes of meeting.
They will be. You knew it. You are there in the helm of affairs in the judicial department. You knew it, that this is the law requirement. Unless you say it's something contrary to what Mr. B. Gogoi says, that's the law. That is what it is. So it is therefore the requirement. When you are being informed that look here, you have 121 in the head of account, kindly provide that. Use it. Use it means you have to submit the proposal for the removal, for getting the cap.
So it is, you're not concerned that there is a cap. Concern is of them. They will either say we cannot or they will say we'll give. But Gogoi says we can do this, we'll give that beyond that cap.
In fact, for compact capping part, this part was probably the higher issue was discussed. How it's like, and before the ratio in the court, whether it should be erased or it should be annexed. In fact, that part already file has been moved. But that 11 lakhs part, whatever is there, let them move a proposal.
No, Mr. Gogoi, we have to move the entire proposals which forms the part of 123. The reason why I'm saying so. Now this budget will lapse.
But then say anything more if it is required, say for another 3-4 months, because there will be election code of conduct.
No. Mr. Gogoi, another thing. The election model code of conduct would have nothing to do with this budget, one. Secondly, because this is a budget on the question of maintenance of the High Court, it has to be. Are you saying that because of the model code of conduct, a person will not get the salary?
No, forget about, we have additional proposal of 123. You are ready to give 121, saying that budgetary provision has this give us 121 first. Forget about 123.
This part also,
We are not on 11 only. For whole 121, give a proposal saying that this is head of account, this money is pending, this is we have already spent or what not, these are the bills, please clear this.
Yes, whatever liability that is placed, of course, because they pointed out the amount that this is line you spent.
No, because this is your communication, you have permitted.
Not it is there, official notes.
Now, removal of the cap may be, you see, there might be, that is another issue which we'll look into it. But for the time being, because you see, the state of Assam would not have an interim budget? They have to have an interim budget now. For this period, they have to have an interim budget, then there will be a full-fledged budget after the elections are over, when a new charge is taken from 1st of June. So prior to that, they will have to have an interim budget. So in this interim budget also, what is required have to be moved. They may not be able to put much, taking into account there is constraint in an interim budget. We understand that. But whatever, because otherwise once this period is over, then the budget would lapse, this amount will also go away.
And there will be, after a few days, they will say this is the ceiling of release, what not. So move prompt. Your meeting will not do.
Lahok.
Well, only one, just one rule. That is. Financial power rule. Yes, but here, rule 2 provides below, power to amend. Notwithstanding anything contained in this rule, government in the finance department may, by general or special order, modify, amend, withdraw or relax any provision in this rule.
That is what he's saying. He will relax it and.
Then why the additional advocate general vouch before this court that will this can?
Oh, he's vouching it before you.
No, nothing personal, my lord. Why he's
No, no.
not understanding? I am addressing him. I am saying,
Listen, he
I'm
is
sorry.
saying state will, he is vouching on behalf of finance interest. He cannot do it. Please listen. Please listen.
I'm sorry. I'm sorry. I'm sorry. I'm extremely sorry. I'm sorry.
So you need a proposal. They will exercise this power of relaxation.
No, fine, my lord. I'm obliged
So
to him.
now let us stop here.
This
Let us see that
1.23
rule
will
which
help us.
which is the rule for capping.
The power is already conferred.
Huh?
184 of the, this is in paragraph 4.
Delegation of financial rules.
Yes.
184.
What is the head of account? There's so much proposal against this head of account.
What is it? 184? এখন নহয়, এখন GFR লাগিব নেকি? এখন this is delegation of financial powers.
TFPR, no, no.
Huh?
TFPR rules.
G?
TFPR. TFPR.
The-
We have referred to paragraph 4 and 8. of my-
No, where's the rule? You have the rule?
1990.
No, এখন নহয়,
Soft-
GFR PR rule. There. There.
Lordships can have it.
You have a copy? So, One 184. Where is it? Here the rule is till 31. You're referring to what rule?
Some serial number, not rule.
Serial 180.
Of the schedule.
Yes.
There's no 184. I've seen in 179.
Serial number. is the Muslim one.
This is the delegation of financial rules. It's another rule.
Financial commercials, 2022.
This is delegation of financial power.
Financial power.
Not there. It says as per finance commission B department notification number.
This is notification.
Ah.
Notification number 180.
Oh,
So some verification has been made on that.
notification.
On this particular.
So you have inserted earlier there was no capping therefore. This notification was issued when?
9/11/2022.
2022.
No. That is the rules.
No. As per finance establishment's notification number dated 9/11/2022 on serial number.
Now,
But you have power of relaxation by decision special order or a general order. You can do that.
They
by
can
the-
do everything.
they are doing
As per finance department, anything within. this rule.
No. You see why I'm saying so? Notwithstanding anything in these rules, the government in the finance union may by general or special order modify, amend, withdraw or relax any provisions of the rules. Meaning thereby, what is there in the rules can be modified. Now the question is, does the rules say about skipping?
I'll have to ascertain. This has come for the.
So are they amending by way of an executive instruction?
That there is something.
No.
We'll go to that also, Milord, whether they can at all.
Capping is by virtue of a notification dated 9/11/2022.
Yes, my lord.
Where is that notification? We let us see the power
Hmm.
issuance of that
Ah.
notification.
Under what provision they have done it? Thereby putting a cap.
Written. এই যোনখন কেপিঙৰ কাৰণে আমি যে দিছিলো যে that is what that is which notification present before your lordship
166.
the capping notification. This is the notification. Clause 3, so and so, all power under the government also pleased to direct following power shall be delegated. General condition.
So what is capping to finance?
Mr. Gugoi, how does this have any application with us?
It's of department judicial, no? It's of department judicial. Section of miscellaneous services including housekeeping or house administrative.
No, that is for only for the judicial department for that
Their
department. This cannot have an application to the High Court. For that it is okay. You cannot have this.
This is suppose this is for his office.
Or in a district.
Yeah.
That will be there.
This capping cannot be there.
So let you give your proposal. You are on a.
No, you give your proposal, but we are otherwise next time we're going to hold this. Otherwise, ask your highest authority to decide on this. Otherwise, we are
This is
going.
clear.
No, we
Capping for using money for an office.
for your office. This cannot go for the High Court.
That's why they have said you expend it from that account, just to keep the financial sanction. That is why, Milord, from last occasion also, Milord, I was also shocked that for 10 lakhs, 2 lakhs requirement for the High Court, so much of formalities. Because what my understanding is that, Milord.
No. Therefore, it is not in pursuance to a power being conferred under this Act rules.
That's why, Milord.
This is an exercise done under 166.
And that's why
It's for them only.
That's why they have written this communication finance department. They are not saying this capping. Therefore, they have said this is his understanding. This is his standard. He is presuming that they will not give us money. You give the proposal, they will do it. This is no relevance of this.
Ask the highest authority to look into it. Otherwise, on the next date we say that this is not applicable. Make it very clear. It cannot be
Is
made.
there any rejection on this point? Formal rejection on this, say, this notification? Where is that?
Show us that. That is enough.
That is enough. Show us that.
We pass an order immediately.
No, they have not. They have said you can use it. They are not saying anything about capping. This is your apprehension. That's why you have written, please amend the rule and whatnot.
You cannot have for the this judiciary 2 lakhs has kept for housing expenditure.
No.
There are more stuff. Yeah, there are more stuff.
More stuff?
And this is for the head of department and for the senior secretary, office of senior secretary and office of head of the department. Therefore, this is capping.
And therefore 10,000 and then to 2 lakhs maximum. This cannot apply for that. But why should we pass an order asking them? No, we are not.
I think their understanding is clear. Otherwise, they would not have written this letter. Already money is there, you can spend it.
So,
the thing is that you submit
where do I get this notification? And when can we get an opinion from there? Rule amend করবো না আগে? This is they have, therefore the rule doesn't say so. You are making these submissions. And Michael's High Court, you should have said, made that submission instead of making all these unnecessary
I'm so
submissions.
sorry, my lord.
Antagonizing
just-
the additional.
I was just
application.
perplexed, my lord. Are we wondering for 2 lakhs, 10 lakhs, 1 crore?
Advocate General was correct in that in that sense.
My learned brother is correct. His instruction
But both
from
of
the
you are
commission.
asking on 2 lakhs and 7 lakhs, and without looking at the notification, this
I
is
was
for
trying to,
something
my lord.
different.
I was trying to get out of this Excel of
Mr. Gogoi,
proposal and. my
when
lord,
we
final-
can get the highest authority's decision
Regarding no, proposals is not here.
on this notification? When?
That line for the highest authority, lordship is posting on 25/2. I will convey, ma'am. In fact, it can be by, I can't say, well, here has been decision. It should be by today or I can't say. For the highest authority, if it gives the final note.
Else we are going to decide this on this notification. And we say that this
Can you
notification,
tell this? This is not the, you just clarify
That's
that.
why he said, if there is no word called capping.
That is
Anything excess amount you want, just give the proposal. It will be sanctioned, but it will have to be put at the.
লেখো Mr. Biswajit Chakraborty, LR Assam, LR, come Secretary to the Government of Assam Judicial Department is present before this court pursuant to the order passed by this court on 5/2/2026. Full stop. He has also submitted a particular written submission submission in compliance to the order passed by this court on 5/2/2026. We have perused the contents thereof. Full stop. This court have inquired with the learned counsels who are appearing on behalf of the parties as to under what basis the capping as stated by the register administration before this court on 5/2/2026 have been imposed. Full stop. Although in the written submission, it has been mentioned, written submission submitted by the LR, it is mentioned that it is being done on the basis of a notification dated 9/11/2022. Thereby the sanction limit delegated to the administrative department is 25,000 per month with annual limit of rupees 2 lakhs. But the same prima facie appears to be only qua the department concerned and does not and would not, in a prima facie opinion, apply to the High Court as well as the District Judiciary of Assam. Full stop. Mr. B. Gogoi, the learned additional Advocate General, has submitted before this court that this very aspect have been taken into consideration by the highest authority. And in a day or two, there is a likelihood that a decision in that regard would be given, taking into account that the highest authority of the state is looking into the said aspect. We would not like to deal with it today. We, however, defer the instant issue to be taken up again on 25/2/2026 for further deliberation. This court we further observe that in the meantime, the Judicial Department of the Government of Assam shall take up the matter with the Finance Department of the Government of Assam as to how the amount of rupees 1.21 crores, which is already there in the budget, within the budgetary sanction under the head housekeeping, can be used towards the proposal submitted by the registry of this court, which led to the supplementary demand of 1.23 crores. An update in that regard be placed before us. Can be released. Huh? Anything more? No capping.
It should not be.
Take a decision on this vessel. We prima facie therefore say there is no capping.
We have personally, I had talked with the commissioner and this should be flawless, man. The amount should be placed at the disposal of the Honorable High Court. As far as the High Court estimated amounts are concerned, budgeted amounts are concerned. And that's in that regard only, things are going to be worked out.
My lord, only one small prayer, my lord. Lordship has recorded the judicial department will move as to how to use this amount. How to release this amount would have been more helpful for us, subject to correction, my lord.
Mr. Das,
The-
we say have mentioned, you have submitted the proposal of 1.23 crores.
Yes.
And as such, it becomes the basis. They will contact with them, how it can be released. These
Release,
proposals
yes.
can be released to you.
Yes,
That
release
is
will
what
help.
we say.
Release will help in the.
We have not,